Thank you. This hearing is in the matter of case number CFI 52-2023 before Justice Rene Lemiere. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. Counsel for the claimant is Mr. Peter Lindstedt. Counsel for the defendant is Mr. Simon Perhar. Thank you.
Yes, well, thank you. Now, there are two applications before the court. The first in time was the defendant's application of 21 December 2023, and then there is the claimant's application of 15 March 2023 to rely upon the claimant's second witness statement on the hearing of the defendant's application. Logically, it seems to me that I should hear the claimant's, or address at least, the claimant's application to rely upon his second witness statement first. Does either counsel have anything to say about that?
No, I think that would be a good idea.
My Lord, can I just add that maybe some of the points that we wish to highlight in the second statement, the claimant wishes to rely upon, may cut matters short. So I don't know whether you wish to hear from me first and before Mr. Lindstedt launches into his full application.
Mr. Penner, does that mean, do you oppose the claimant relying upon his second witness statement?
No, in essence, we do not oppose the court allowing the second witness statement. However, we do have some points that we would wish to highlight given the lateness within which the application was made last week.
Well, if you don't oppose the claimant relying upon his second witness statement, then it seems to me the proper course is that I give permission for the claimant to rely upon that witness statement. We will then proceed with your application, and of course, in the course of that application, you can make such relevant or proper submissions in relation to that witness statement as you see fit.
I'm very grateful, my Lord. I think that's helpful. So we can then move on to deal with the substantive application subject to anything else that Mr. Lindstedt may want to say.
All right, very well. Well, I then will order that the claimant has permission to rely upon his second witness statement dated 13 March 2024 on the hearing of the defendant's application of 21 December 2023, which is now before the court. Very well. Well, Mr. Penhar, sorry, do you pronounce your name? Is it Penhar?
No, it's not actually an N, it's an R. So it's Perhar, P-E-R.
Perhar.
Yeah, much easier.
You. Yes, well, thank you, Mr. Perhar. Would you please proceed?
Your Honour, there is one other preliminary matter.
Yes.
If I may. And that is that it's correct that there were two applications before you and are two applications before you today. I need to make the observation that the defendant in its skeleton argument appears to be raising a third application before you, which is to strike out the claim on the basis of abuse of process arguments. And that is essentially what their skeleton argument says, in particular paragraph 97. And the observation is that, leaving aside the fact the allegations being made against the claimant are denied and we say grossly exaggerated, it's improper to try and introduce a completely new application by way of a skeleton argument. That is a matter which should have been brought to the court by application in the normal way. It hasn't been. The application notice before you is based only on an allegation of defective service of the claim form. There is no time to deal with a new application and the 7 authorities relating to that, which were served by the defendants on Monday. So I simply make that observation, and I ask the court to disregard pages 32 to 35 of the defendant's skeleton argument, which contains that material. I also make the observation that the skeleton argument itself runs to 36 pages, in addition to 9 pages of submissions which were submitted with the original claim. And therefore that exceeds the page limit, which is made clear in the rule. Now, I'm not asking you to do anything specific about that. It's entirely a matter for the court. But I do make the observation also that a significant amount of that skeleton is taken up with disputed facts and issues about the claimant's character, all of which are irrelevant to the matters before you. That's all I need to say at present, but I wanted to highlight that one issue at the outset.
Well, it seems to me that there are, in a sense, 2 issues of the nature that you have identified, Mr. Linstead, and they are this. In your submissions, in the claimant's submissions, indeed, in his application to rely upon his second witness statement, the claimant says that the defendant's application was made solely on the basis that the claim form in the court of first instance was not properly served as it was sent by email. Now, it appears that in the defendant's skeleton argument, and I'm not sure, possibly in the defendant's submissions in support of its application, the defendant appears to raise 2 other grounds. One is the abusive process, which you have just identified and referred to, Mr. Linstead. The other is what I think the defendant refers to as the broader limitation point. Now, Mr. Perha may say otherwise, but on one view, that ground is not raised in the application either. So I'll allow Mr. Perha to develop his arguments and his submissions as he sees fit. But Mr. Perha, you have that point or those 2 points to deal with. That is your application solely based on the claim form in the court of first instance having not properly been served, and based upon that, the relief you seek that in the form of a declaration that the court should not exercise its jurisdiction, which it may have in respect of the claim, and the other relief you seek, rather than a declaration that the court does not have jurisdiction, which might be thought to be the appropriate relief if you are right in the limitation argument. So, as I say, I will allow you to develop your presentation as you see fit, but you're on notice that the only matter which it is conceded is the subject of your application is the argument that the claim form in the court of first instance was not properly served, and that should give rise to the relief you claim in your application. You'll have to, if you wish to advance the other arguments put variously in your skeleton argument and possibly in the submissions, you will have to address those points. So over to you, Mr. Perha.
I'm very grateful, my lord, and hopefully as I develop my submissions to the court, it should become clear how those other matters fit in to the considerations that the court has to take into account today in reaching a conclusion on the matter. Having said that, my lord, if I could just start, can I just check actually the timetable with your lordship for today? Yes. And timings, because I think I don't know if your lordship is in this jurisdiction, but just so we all know where we are.
All right. Well, can I start? Whilst being addressed as your lordship is always very pleasant, I think the correct way of addressing me is Your Honour.
Your Honour, I will.
My home jurisdiction, as it were, is Australia, and lords and ladies no longer sit, if they ever did, on our courts. So it's Your Honour, if you please. Secondly, yes, indeed, I'm sitting in Western Australia. The time, as I understand it, well, I think Mr. Lindstedt is in London, and it has gone a little after 8 a.m. I'm not sure where you are, Mr. Perha. Where are you?
No, I'm in the UAE. I am in the DIFC. Yes. Yeah. So it's 12.
It's a little after noon there.
Yeah.
And it's a little after 4 p.m. for me. The time which has been scheduled for the hearing is 4 hours, commencing, if we take the DIFC time from 12 noon in the DIFC, so 12 till 4 o'clock. I would, well, I'll ask you in a moment how long you think your submissions are going to be, Mr. Perha. If on the assumption that you will take up to 2 hours, I would propose to take a break after you have completed your submissions, the length of which might depend upon the time we reach. But I have in mind the guideline that you should have up to 2 hours for your submissions, Mr. Perha, and then we'll go from there.
I'm very grateful, Your Honour. And so if I start, hopefully I can give you an indication where I'm at some point. And if it looks like it's going to go on a bit, I'll let you know.
All right.
Thank you. Thanks very much. I propose to take the court through my submissions, which, for Your Honour's reference, are at 824 to 882, but please don't turn to those yet. And the 4 agenda points outlined at section D of my submissions on page 844, which I can summarise at the start as follows. So agenda item 1, the SCT filing and the consequences of that, which starts at, for Your Honour's reference, page 844. This submission will focus on the claimant's miscalculated decision to file in the SCT, surpassing the jurisdictional limits and falsely declaring mutual consent. It highlights the impact of this misstep, including the SCT's dismissal of the claim and the broader point of the jurisdictional boundaries. So that's agenda item number 1. Agenda item number 2.
Well, before you go any further, is that, hesitate to use the words, but what ground of your application does that go to? If I was to, if you make out those points, what is the basis upon which they lead to the relief that you now seek? And in particular, if I cut to the chase, and in Mr. Linstead's opening remarks, do those matters go to an argument that the claimant's claim should be dismissed on the ground, or dismissed or struck out on the ground that it is an abuse of the process of the court? Or do they lead or support the argument that the claim is brought beyond the limitation period in sections 10 or 61 of the employment law? Or do they go to some other ground on which the relief you seek may be granted?
Your Honour, in fact, they go to a degree to all of those. In that this submission about the election by the claimant at the outset to choose the SCT and the circumstances surrounding that is of critical importance for the court in making its decision, not least on the basis of the way that the case is put on behalf of the defendant, but in addition, the manner within which the claimant is asking the court to exercise its jurisdiction and discretion in relation to a number of matters. So in that regard, the court has to have a understanding of the matter in the round, and all of this comes into play. So the impact of all the circumstances that your Honour's just outlined is relevant to agenda point 1.
All right, well, my present view is that I will permit you to proceed with that argument, but my present inclination, which you may, which is open to be persuaded otherwise, is that there is no application before the court that the claim should be dismissed or struck out on the ground that it is an abusive process pursuant to Rule 4.16 sub Rule 2 or otherwise, and hence I want to make it plain that in allowing you to make these submissions, because, as you say, they are relevant to the exercise of the discretion which the claimant seeks in the alternative, in doing that, I am not treating those submissions, or rather, I'll start that again. My present view is that it is not open to you to submit that the claim should be dismissed as an abusive process, as say, pursuant to Rule 4.16(2) or otherwise.
You're right. If it assists, I agree with that proposition. So that probably cuts those down. We haven't made an application under 4.16.2, no. But I think Your Honour's quite rightly actually set out the basis upon which those matters which I raise do come into consideration, right. And the discretionary part is a large part of that argument.
Well, it's part. Or it is relevant to the claimant's, if I can call it, fallback position, the claimant's case over. As I understand it, the claimant's primary case is that service was properly effected, and it is then the and at the moment, it seems to me that the arguments you've just, or the submissions you've just foreshadowed, are not relevant to that argument. But the claimant then says, as I understand it, if it is wrong and that service was not properly effected, then it seeks the exercise of the court's discretion to remedy a procedural error. And as I understand what you're telling me, you then call in aid as relevant the matters you just referred to as relevant to the exercise of that discretion.
Yes.
All right, thank you.
And then just so I can outline at this stage, the broader issue, which we say is in play, is the Limitation Act point under the employment legislation in relation to the transfer, which I'll address you on, in which will make more sense as I develop my submissions, the transfer from the SCT to the CFI.
Well, if that is an independent point, that is, I don't know, it seems that your submission is that the expiry of the relevant limitation periods is relevant to the question of whether or not service was properly effected. For the moment, I don't see that, but you might be able to show me why that's relevant. But if you go beyond that and seek to raise the expiry of the limitation periods as an independent point, I'm not yet persuaded that that is a matter open to you to advance on the basis that your application doesn't put forward such a ground. That is, to put it another way, if the application, if the claim form in the CFI was properly served, I'm not yet persuaded that the court might then consider whether or not the claim is statute barred in any event, notwithstanding the claim form was properly served. So as long as we understand each other on that, we can carry on.
Okay. Thank you. Well, that's very helpful, Your Honour. Then I'll just run through quickly the other agenda items, which I'm sure you've already seen in our submissions. But there's agenda item number 2, which is the service point, which is at page 849 of my submissions. And then I'll just highlight these points quickly now. Obviously, I've heard what Your Honour has said, and hopefully during the course of my submission, everything should become clearer in where we're coming from. There's the third agenda item, which is at page 853, and then the fourth agenda, sorry, and that was the limitation period challenge. And then the fourth agenda item, which was the abusive process argument, which is at 855 of my submissions. So before turning to those points in detail, I would like to draw to Your Honour's attention some of the key documents that are relevant to the consideration before the court today. I beg Your Honour's pardon, but I didn't ask at the start whether you'd had an opportunity to consider the papers before today.
I have, yes.
I'm very grateful. I'm very grateful. So that helps, Your Honour. I will then proceed with a light touch, highlighting key passages in the critical documents. Your Honour, the first document, which we don't need to turn to again, I'll just highlight. So I'm sure Your Honour knows where it is. Page 133 is the contract of employment. Nothing turns on that in terms of the application that is before the court today. Probably the key document starting the antagonism, for want of a better phrase, between the parties is the complaint by Miss Ahmed of the defendant, which is dated Friday 10th of June 2022, which effectively lights the touch paper on the issues between the parties, is at page 147 of the bundle. And I would invite you, Your Honour, to read this document in full in your own time, if you've not been able to do so already. But in essence, to distill down what the document is about, is it summarises complaints about the claimant's behaviour and altercations with other colleagues and overall performance within the defendant organisation since the claimant had joined. But most seriously, what is the reason for her writing down this complaint was that there was an incident on Friday the 10th of June where the claimant had entered Miss Ahmed's room and left her feeling threatened, as she's detailed in her in that note from pages 148 to 151 and paragraphs 1 to 7 of the complaint letter set out the background. And what we say is that the claimant's resignation was prompted by this complaint that was made by Miss Ahmed. And the reason this background is relevant and helpful, and I'll try and skip through it as quickly as possible, should become apparent to Your Honour. The resignation notice that followed that incident on the Friday was on Sunday, 12th of June by the claimant, and which can be found at page 160 of the bundle. I will invite Your Honour to briefly turn up this document. The court is invited to note that at this stage, even as far back as June 2022, the claimant had stated at paragraphs 4 and 5 of this resignation document that he intended to bring claims under DIFC employment law, which he seemed to be well acquainted with. If Your Honour could then look over the page at 161, Your Honour will see an email dated the same day, which is the Sunday, 12th of June. And what we say is that the claimant had been in the defendant's office over the course of the weekend after the altercation with Miss Ahmed on the Friday. And it is assumed by the defendant that he went into Mr. Singh's office, and his office was not locked, and he saw the complaint from Miss Ahmed on the desk, which she'd placed there on Friday evening. And what we say is that, realizing that he overstepped the mark on the Friday, he decided to make a preemptive strike, for want of a better phrase, by resigning first, fearing that he may be dismissed on the Monday. The claimant did return to work on Monday, and when he did return to work, he was asked to work from home. He did so. He wasn't dismissed on that Monday, and then when he did come back into the office after the short period at home, he continued to be difficult and aggressive in the office environment and entering into arguments with other colleagues. If I can ask you to turn to page 165 of the bundle.
I will, but when you're doing that, I'm getting a little concerned that we seem to be being overly concerned with the merits of the claim.
Yeah, I can understand why you'd have that apprehension. I think I'll try and go through as quickly as I can. I think to have the background context is critically important for you to understand the claimant's subsequent actions in the filing of his claim, and then for the exercise of the potential discretion which you may be asked to exercise by Mr. Linstead.
So I do just interject, if I may, at this point. It is probably obvious that all the matters being raised are matters of dispute,
Oh, yes.
and therefore completely irrelevant to the matters in front of you.
Well, I'm going to let Mr. Perha continue for the moment. I've attempted to, as it were, put him on notice that I'm not yet persuaded why these matters are relevant. But I'm going to let him develop the argument and see if they do become relevant. Mr. Lindstead, you can rest assured that I'm not a jury, and that listening to these matters if I deem them not relevant, they're not going to affect my decision.
Yeah, they could go to relevance, or they will go to relevance in Your Honour exercising any decision making in relation to the discretionary powers that you're asked to exercise. And all I would say is that it goes to the state of mind of the claimant at the time, and also the timing is important for the court to then make any decisions that it needs to make in relation to that discretion, which Mr. Lindstead will ask you to exercise, or may ask you to exercise. So therefore, I do bear in mind what Your Honour says, so I will try to go through as quickly as possible and not dwell on matters that are disputes of fact, because I'm certainly not expecting you to decide any of those. So I'll just skip through the documents, and Your Honour can make a note of them, and then if you require to go back, then you can do. So page 165 is an example of the claimant entering into dispute with a female colleague, Miss Polemans. What we say is what's indicative of the claimant's attitude, and it may be that the court does need to determine attitude in deciding discretion, is the pejorative language that was used by the claimant. At the bottom of page 61, he describes his female colleague as irate, manic, flapping, hostile, and aggressive. And what we say is that there's a general disregard not only for colleagues by the claimant, but for rules in general, and that will come through.
I have to say, Mr. Perha, that seems rather a long bow to go from description of a colleague one way to inferring from that a disregard for court rules. But
no, I can understand. I can understand where why you say what you say, but hopefully by the end of my submissions, you'll see that they tie into what you will be required to consider today. Whilst every single point may not strictly be, and you're not in a position to weigh up whether one point is better than another, I totally appreciate that. But hopefully when you're asked to make a decision at the end, this will be helpful when you go back and look at what the conduct of the claimant was from the outset of these proceedings. So what we say is the whole claim was orchestrated by the claimant arising from this original complaint by Ms. Ahmed. We say that the claimant had decided at this point, back in June 2022, that he was going to pursue a financial remedy, and he'd hoped that his behaviour from that point onwards was very much geared towards looking to achieve an outcome, a financial outcome, and an exit from the organisation. So I won't say anything more on that. If we can move on. As at page 170, and again, Your Honour doesn't need to go to it, is the detailed reply to the 10th of October email, which I've just taken Your Honour to. That's the detailed reply from the defendant. That deals with the defendant's standpoint and view from the point of the incident with Ms. Ahmed all the way through to October 2026 when the letter is written. And if we could then go on to the 19th of December, which is the termination letter for cause at page 191. This sets out very clearly that the claimant had gone off on sick leave in September. He hadn't returned back to work. And so September, October, November, December, by December, it had been decided, as set out in that letter and the reasons set out in that letter, that the claimant would be terminated for cause. So that date is important because that's the That's the date from which we say the limitation period starts, the 19th of December 2022. And finally, just for your honour's reference, the claimant's biography in terms of his role that he carries out and his skills is at page 111 of the bundle. There's just one further document which I've missed, but you have probably looked at it, and again, Your Honour can look at it in Your Honour's time if you need to, which is page 160, which is the claimant's notice of resignation, which I don't know if I took you to that, but that sets out what we highlight in that document. Is that document sets out the claimant's intention from June 2022 to bring these claims, and we say everything has to be looked at from that date onwards when deciding if deciding the claimant's conduct and how it impacts on the application before the court today. So moving on swiftly, after his dismissal for cause on the 19th of December 2022, the claimant had a strict 6 months under DFC employment law to file a claim. I don't think this is in dispute. So that deadline was the 18th of June 2023. So they're the two dates the court we'd ask the court to have in mind, is the 18th of June 2023, the 19th of December 2022. Now, the SCT regime, as Your Honour will be fully aware, is a discrete informal regime within the DIFC with a significant distinction from the Court of First Instance, the CFI. If I could at this point invite Your Honour to look at part 53, page 449. And if Your Honour is fully versed in this particular rules and procedure, please do say, and I can go through with a lighter touch to save time.
I am familiar with it, but please, whatever particular provisions you want to rely upon and what you make of them, tell me.
Well, if I then first go to the SCT claim form, it's probably the best way to do it, page 3 of the bundle. If I can invite Your Honour to go to that.
Yes.
Right, you'll see that the issue date is the 15th of June 2023, and the claim number is SCT 228/2023.
Yes.
And then if Your Honour could turn to page 6 of the bundle, the claim amount is recorded in the SCT form as 892022.09. And it's critical for the court to note that here it's been written by the claimant that the claim exceeds AED 500,000 and that all parties have elected in writing to proceed in the DIFC Court Small Claims Tribunal.
Yes.
And then moreover, this is followed by a statement of truth. So I think that's all pretty indisputable there. So then coming back to the point in relation to the RDC and part 53, this is at page 449 of the bundle. So if I can invite Your Honour to turn to that.
Yes.
So Your Honour, again, I don't think these are particularly controversial clauses. Paragraph 449 at page 449, Article 53(1) uses the terminology, which I think is important for the court to have clear here, is Article 53(1)(1) set out a special procedure for dealing with claims, and I think this will become more important as we look at the service of the claim eventually. But it's a special procedure, and then it's not in dispute. 53.2, the SCT will hear and determine claims within the jurisdiction of the DSC where the amount does not exceed 500,000 AED. And part 2, where the claim relates to employment or former employment of a party, and all parties elect in writing that it be heard by the SCT. There is no value for the SCT's elective jurisdiction in the context of employment claims. So I think it's quite important here that we are in and we get the distinction that we're dealing not just with an SCT claim, but an employment claim within the SCT claim, because these distinctions are important. So I'll come on to the SCT in a little bit more detail during my submissions, which I will develop as part of the agenda 1. But at this point, all I invite your lordship to note, and I don't think it's controversial between the parties, is that there has not been an election at this point by the defendant to be subject to the SCT regime, and the SCT regime is quite strict in terms of, well, it's very strict in terms of what has to be agreed between the parties in order for the regime to apply. So, my lord, my Your Honour, you're coming on to the point that the SCT contains a statement of truth. What follows from this, and I'll take this point quickly, bearing in mind what Your Honour said at the outset, what follows, and it is important, is that the claimant has signed a statement of truth in the SCT claim form that all parties have elected in writing to proceed in the DIFC Small Claims Court, when that was not the case. And I'll come on to and explain in more detail where the court can find evidence which shows that the claimant knew that was not the case. So it's quite a serious point there that he's stated with a statement of truth that the parties have elected at this stage to be subject to the SCT. So trying to move through the documents that I'm just highlighting them. Page 11, if you would, Your Honour, is the notice of service. It shows that the SCT claim form was served by the DFC on the 5th, or the registry on the 15th of June 2023. I'm afraid you have to jump a little bit here, but just to keep the narrative and the chronology, page 201 of the bundle is the evidence of the filing, is the email from the registry. It's the bottom of the page. That at 8:40, there's an email at 8:41 AM at the bottom of page 201 that the SCT claims served by email on the defendant from the registry at 8:41 AM.
Yes.
After the SCT served the claim form on the 15th of June, the defendant was required to file its acknowledgement of service, which it did, which is at page 12. I'll go back to that, but whilst you're on this page at 201,
Oh. Yes,
you can see at the top of the page an email from the defendant at the very start of this process. And this is a very important email, as the defendant, in the context of this application of dispute, as the defendant contends the claimant was on notice as of the 16th of June, or 15th of June 2023, that the defendant was contesting jurisdiction and the exact reasons why it was. It says there on the 15th of June, and the claimant is copied in, for the avoidance we dispute the jurisdiction of the SCT given the value of the claim, the complexity of the matter, and critically the absence of any agreement between the parties electing the SCT as the forum for the alleged claims. In our view, this is a CFI matter and can be appropriately addressed in the CFI. So at that very outset, from the 15th of June, the defendant had made it quite clear in no uncertain terms that it was disputing jurisdiction on two grounds. At that point, first, the value of the claim exceeding the jurisdiction threshold, but more importantly, the defendant made it plain that the parties had not agreed in writing to elect the jurisdiction of the SCT. Now, how does that affect the application before the court today? Well, what this does mean is that in strict terms of limitation, that on the 15th of June 2023, and I'll expand on this in a moment, 3 days before, 3 clear days before the expiry of the employment limitation period on the 18th of June 2023, the claimant knew that his false declaration in the SCT that the defendant had agreed to the jurisdiction of the SCT had been formally contested. So whatever was going through the claimant's mind in saying and stating and signing a statement of truth to the effect that the defendant was agreeing to the SCT, as of 15th of June, he knew categorically at 6:45 p.m. that the defendant was not submitting to that jurisdiction. So on the 16th of June, the defendant issued the formal application to contest the jurisdiction, which is at page 14 for your honours reference. Again, we don't need to go to that. What's helpful now, just to finish off on the potential claimant's state of mind and evidence that the court has in front of it, which may assist it in its final decision that it's required to make today, is for your lordship to turn to page 17 of the bundle. This is quite an enlightening document, for want of a better phrase, for the purposes of the application before the court today, where it's not tasked or nor can it make findings of fact. These are actually the words from the claimant himself. So if I could start, please, by inviting the court to turn to page 23 of this document. So at page 46, so page 23, paragraph 46. The heading, and this is the claimant's document, the defendant's submissions with the title Elective Jurisdiction of the SCT. So paragraph 46 and paragraph 48, the claimant therein unequivocally admits the quantum threshold is exceeded, but more importantly, he says that at paragraph 47, but more importantly, paragraph 48, he says the claimant acknowledges that there is no formal correspondence from the defendant expressly confirming agreement that these proceedings be heard by the SCT. So putting all those things together, the regime under Part 53, which the claimant will have been aware of, the signature of the statement of truth, the false declaration, the court can conclude on the basis of the documents that have been provided by the claimant himself that actually he did falsely make that declaration. It cannot be an issue in dispute whether or not he made that, because it's a black and white fact from the claimant's own admission and statement therein. There's been no attempt to resile from that statement or no correspondence to suggest that it was a mistake. So we say that's quite a startling open admission and in no way qualified. So So the point being, the claimant's declaration on his SCT claim form that the parties had elected the SCT's jurisdiction in writing, and this is the point, was not an innocent or genuine mistake. It was a deliberate and miscalculated action. However, we can go on, there's more, it's not just that in this document. When one reads on to determine the state of the mind of the claimant at this point, actually the statement becomes ever more bemusing, not least because he is a qualified lawyer. We're not talking about a lay person here. He continues at paragraph 48, despite making the admission that there was nothing in writing, but he continues, and we say quite arrogantly, but it is the claimant's position that it was still reasonable and in the interests of all for the proceedings to be issued in the SCT. Now, that's just not possible without a party agreeing, and the defendant simply didn't agree and does not agree and never did agree that the SCT was the appropriate forum. And what we say, and I think it's important for the court,
Mr. Perham, it may not matter, but it is not unknown for a party to commence proceedings in the SCT claiming, in an employment matter, claiming more than 500,000 dirhams without having obtained the prior consent of the defendant, and subsequently for the parties to agree that the matter should continue in the SCT. Now that, of course, is a separate matter from what you have described as the false declaration, but as to whether or not it was reasonable for the claimant to say that it was reasonable to commence the matter in the SCT, that's a different issue.
I hear you on it, and I think there are a number of points that arise from your Honour's very sensible and reasonable observation. And I think that each of these circumstances, whenever they rise, have to be examined on their own particular circumstances. And in the context of this case, where the claimant is a qualified lawyer, I would submit that the burden is a little higher. And the consequence of filing and stating that a party has agreed to a jurisdiction is not an innocent mistake in the context of and circumstances of this case. I can take you to something further, which in my submission really bolsters the fact that it isn't innocent and it was calculated, and we say miscalculated, and largely you'll hear towards the end of my submission, we say that the claimant is the author of his own misfortune to this regard. But if you just stay on that document rather than jumping around, if you look at paragraph 72 of his submission, and we say this is and was the motive of the claimant. There wasn't just simply innocent representation made in the manner that your Honour outlines, which some claimants may do and defendants may agree to stay within the SCT. The claimant had in his mind that he did not wish this matter to be publicised, and so he says at paragraph 72, one of the major benefits of the SCT is the privacy afforded to litigants, which the parties to this case require. It aims to help parties take a conciliatory approach. In itself, that seems sensible enough, but the claimant is still relatively new to his current employer when proceedings had to be issued, and is still in the early years of his post-qualification legal career in a country that is also new to him. In the event proceedings are transferred to the CFI, the claimant is at risk of being brought thought of less favourably as an employee and in the job market, both here and in the United Kingdom, simply because suffering of the stigma that can be attached to an employee, and it should be an employer, especially in a claim of this nature. The claimant's career risks being jeopardised as an unfortunate consequence. The claimant submits that his decision to issue proceeds the SCT in an unavoidable necessity in the interest of the parties and the courts. And we say it's quite arrogant for the claimant in this instance, in the circumstances of this case, to be telling the court what is right for the defendant to be doing in the circumstances, and was the right choice in the circumstance. It was not on a whim or without properly considering. So there's a thought process behind it. There was a proper consideration, and yet he still signed the statement of truth, knowing it to be false. Now, if the claimant was being transparent about what he was doing and being straightforward and acting professionally, then he would have ensured that he sought the approval and obtained the approval of the defendant before submitting to the SCT. Essentially, with the deadline approaching, with the employment deadline approaching of the 18th of June, he left a mere 3 days and took the risk of issuing in the SCT. Let's not forget he had the whole benefit of the 5.5 months or 6 months almost before that, but he chose not to take that. So he increased the risk to himself that something could go wrong, and which it did. Now, there's one other paragraph which I'd highlight to you, which again underlines the point that I make within his own submissions, which is at paragraph 52 on page 24. So at paragraph 52, in the reasonable opinion of the claimant, so he's talking about his request. In fact, he did make a request for the SCT to the defendant. So paragraph 51, just over the page at the bottom, he says that he asked them. So actually, we say this aggravates and exacerbates the fact that the claimant signed a document which he knew to be untrue. And this has to be a factor that's taken into account by the court. So he says the defendant remained silent in both emails. So he sent 1st of June, the defendant replied to that, and these were golden opportunities for them to reply, and they remained silent. So silence in this context doesn't constitute acceptance of the SCT regime. But he goes on at paragraph 52. He says, in the reasoned opinion of the claimant, this was a deliberate posturing tactic, and that despite the warning, even had he specially asked or requested whether the defendant would be amenable to the proceedings to be brought before the SCT, as would be reasonable in the circumstances, the defendant would likely have either remained silent or rejected the proposal. So the claimant knew at this point, given RDC 53 and the requirements for both parties, given the amount of the claim, to agree and elect to that jurisdiction, that he was undertaking a huge risk by issuing his claim in the SCT, and that it would be very likely to be struck out because it wasn't in compliance with the rules. So therefore, on the 15th, when he received that email at page 201 that I took you to, he knew that the claimant had.
Well, this might depend on other submissions you're going to make that you put in your skeleton, but it may be put by Mr. Lindstedt or by the claimant that the risk he was taking was not that his claim would be struck out, but that it would be transferred to the court of first instance.
Your Honour, on that point, I do intend to make submissions on the
Yeah.
point of transfer, but if I may just come to that in line with
Sure.
my submissions, I think it will be more logical and help the court. But I have got the point, and I will address that point in due course. See what the defendant submits, and I hear what Your Honour says and what Mr. Linstead may indeed say, but what the defendant says is the motive of the claimant, and it's not for the court to determine the motive. I say this as a submission which the court can add some weight, but certainly it's not a determinative factor which the court can make any firm conclusion on. But we say the motive of the claimant was to try and reach a quick financial settlement with the defendant. If at paragraph 49, so final reference to this document, you'll see that, and again, that you can read this both ways. So I'm not asking the court to make any final determination on it, but what the defendant does, so the claimant does, is he talks about settlement and achieving an outcome. And what we say is that from the very beginning, from June, when the issue was raised with Ms. Ahmed, that the claimant has been concerned with trying to put the defendant into a situation or create a situation where it will capitulate and reach a settlement agreement with him, when that simply is not going to be the case. So what we say is that the conduct of the defendant, the claimant, has been entirely misconceived, and his decision to issue the claim in the SCT in the circumstances was motivated entirely wrongly and on an entirely incorrect assumption. In fact, not just an assumption, he knew it was the incorrect forum, but he issued it in that forum in any event. So if I can move on, coming on to your point there that's been raised, is that the transfer. So His Excellency Justice Nasser transfer the matter. It's 34 to 36 of the documents from the SCT to the CFI. Now, let's just look at that order. And I think this is where I want to develop my legal submissions later on. So I just want to lay down that marker now. So the jurisdictional, you'll see at 34, the jurisdictional challenge is granted. The claim shall be transferred to the DIFC court of first instance. Each party shall bear its own costs. Now, under the RDC, sorry, if I could just bear me 1 second. Apologies, no, Your Honour, I'm just going to come up to the page. Yes, so Your Honour, under the RDC, we don't dispute that a claim can be transferred between the SCT and the CFI. There's no dispute on that point whatsoever. However, what we do contend for, which I'll expand upon in my submissions, is that transfer in itself does not preserve any limitation period that may have existed at the issuance of the original claim. And I'll come on to this in a moment, so please just bear with me. I'm just laying that down now. So in the order, the judge ordered that it was transferred, but as I said, that's not the answer to the claimant's problem. So if we turn to page 449 of the RDC, Your Honour. That's the RBC Part 53 procedure, which I touched upon earlier on, and I said I would come back to. Now, we submit this is a discrete framework regime which applies to claims being brought in the SCT. 53.1, I already took you through it. Really, in fact, refers to a special procedure, as that is what it is issues in the SCT or transfer to the SCT. Section 53, Article 53.2 sets out the jurisdiction of the SCT, which we've referred to. 53.3 is important as it refers to the election by the parties, where parties have elected to the SCT's jurisdiction in writing. Neither party shall be able to withdraw such election without the approval of an SCT judge. So the election is significant. And if the claimant would have read this, he would have known that when making his declaration in respect to the election, it is a significant declaration because once it's made, the parties cannot withdraw without the approval of an SCT judge. Now, the wording here, I think, does require some careful analysis. The SC3T, SCT 53.41, which is at page 455, which is the mechanism which is relied upon by the claimant, says very carefully, where appropriate, the SCT judge may issue a reasoned order that the small claim be transferred to the court of first instance to be progressed as a fresh claim under the procedures followed by the CFI. The emphasis I would put here is on the word fresh, and that should be read literally as in new and not in continuation as contended for by the claimant. And I'll develop this point in my legal submissions as I go on to the different parts of the agendas. The CFI proceedings, which are distinct, and it's the point that we stress, must be started by a claim form. I think that's well known, or part 7 or part 8. So that's at page 468 of the bundle, and I invite you on just to quickly turn to that. How to start proceedings, and it's the use of the word start. It's not continuation, it's start proceedings, except as provided for by a practice regulation. Proceedings must be started, and it's must by a claim form. There isn't actually a mechanism that exists which the claimant argues for of continuation of any claim. A new claim, fresh claim, must be started by a claim form under part 7 or part 8, and the forms which are distinct from the SCT claim forms are P701 and form P801. And then if we go to over the page to 7.3 at page 469, proceedings are started when the court issues a claim form at the request of the claimant, RDC 7.3. That CFI claim form was therefore issued at the request of the claimant as evidenced by the email sent by the registry, and this is the next key date, on the 25th of July 2022. And that's at page, we don't need to turn to it now because I'll come back to it, page 37 for your honour's note, 37 and 38 of the bundle. And the
claim.
I'm sorry, Your Honour, I missed that.
37 and 38 is the CFI claim form.
Oh, sorry, I think it's 27 and 28. It's a typo on mine. No, I apologise. I've got the wrong reference in there. I'll come back to that in my note.
All right, so yeah, it's not 27 either, but
So let me just find out. The CFI claim form 25th of July. It is 3738. It's in the
Yes, the claim form. I thought you were referring to an email, which I thought you said there was an email which requested the issue of the claim form. I may have misunderstood you.
Yeah, I'll come back to that point if I may. Or I'm just going to find
Yes,
that
of
note
course.
of where I've put that.
Yes.
So the date of start of proceedings under the RDC, and this is 7.5 and 7.8. The title says the date of the start of proceedings is to the date of issue. So I'm sorry, I'm going back now. I do apologise to the RDC document at 469. And 7.8 is important in the context of this application. Parties proposing to start a claim, which is approaching the expiry of the limitation period, should recognise the potential importance of establishing the date the claim form was received by the registry, and should themselves make arrangements to record the date. So the point is the use of the SCT order of His Honour Judge Nasser to transfer the case to the Court of First Instance cannot properly be construed to mean to leapfrog the jurisdictional boundaries, especially in the circumstances of this case, where the claimant issued the SCT claim in the circumstances I've just described to you, knowing that the defendant was not going to submit to the SCT jurisdiction. So,
but your submissions, as I understand them, ignore or give no weight to the rules providing for transfer and the order providing for transfer. The effect of your submissions is that there was no transfer of the action. You say it simply, in effect, it was dismissed. But that, and it left, and that left the claimant to elect or to be at liberty to commence a new claim or not commence a new claim. But that seems to ignore the order that was actually made and the rules which provide for transfer. You treat your submissions as to say, in effect, well, the rules might have referred to transfer and the judge may have ordered that it be transferred, but that's not what happened. Notwithstanding all of that, I should treat it as the claimant having been dismissed and the claimant being at liberty but not obliged to commence a new action. So on your submission, as I understand it, well, I don't understand this part of it. As I understand the facts, and you may tell me this is wrong, but the claimant didn't elect to commence a new action in the CFI. Indeed, I don't think the claimant did issue a new claim form. As I understand it, the court issued the new claim form on the basis that the claim had been transferred to the court, and to give effect to that order, the court issued the claim form. So there was no option, if you like, for the matter not to proceed. It wasn't a matter of the claim's been dismissed. It's now for the claimant to choose whether or not to commence an action in the CFI. None of that happened, and none of that would be consistent with the order made by the SCT judge.
Your Honor, if it helps, I think I find myself agreeing with a lot of what you said, but there is an important very subtle distinction within the circumstances as described by order. Firstly, there is a transfer and there is an order, and it's not the defendant's submission that no weight should be attached to the transfer or the order. Now, I think what's important here is to look at the SCT.
Well, can you tell me this, Mr. Pratt? In saying, do you agree that something was transferred?
No, I do.
It was the claim that was transferred. Secondly, it was the claim that was transferred, and it's not the case that somewhere between the SCT and the CFI, the claim ceased to exist and then was reborn in arriving at the CFI as a, I shouldn't use analogies, but that's not what you say, is it?
No, it is actually what I say, and I'll explain why. I'll explain why I say that and how I say that and the reasons behind that. Follows. If it's quite helpful to look at 53.42, it's all about how the rules are construed, and what we say is that if you look at the rules here very carefully.
Remind me, where do I find that rule in
page 455.
Thank you. Yes, I have it.
So a claimant, so 53.42, it's 3/4 of the way down the page. A claimant in an SCT claim that has been transferred to the CFI. So we've got 53.41 before Judge Nasser's order, 53.41's engaged, transferred over. In accordance with 53.41, is at liberty to pursue its claim in the CFI by filing a Part 7 claim form. And this is where I think the construction of the rules is very important, because one of the things that I was originally troubled with the transfer was that, so what happens where there's a transfer and does that mean that the case has to proceed? And that's the point that your Honour was just making. The case must proceed. Now that cannot be right. So what is very carefully written within the rules when you construe them is that the transfer happens of, I think it's confusing, terminology can be confusing, the cause of action or whatever, the potential claim that's going to be heard in the CFI. And then the claimant is at liberty. So your Honour said there is not an option, but actually there is an option. So you at that point are at liberty to pursue the claim in the CFI by filing a Part 7 claim or not file a claim in the CFI. Now, in my respectful submission, that distinction and that option is critical to the argument regarding continuity, because it is not the case where the court is saying, by virtue of you having issued a claim in the SCT, we will transfer that claim over to the CFI. If there was no requirement, and it comes on to my next point, for a fresh, and this is where the word fresh comes back in to play, a fresh CFI claim, which is required to commence the CFI jurisdiction, then that would be a different point. So in my respectful submission, that a careful construction and analysis of the rules reveals the fact that the regimes, I think we are all clear, are entirely distinct from each other, that there does not exist a mechanism within the rules for a CST claim to be transferred extant to the CFI as a CSCT claim. Yeah, 53.41 is very clear in that it says to be progressed as a fresh claim under the procedures of the CFI, which are the Part 7 procedures of the CFI, which I took your honour to briefly earlier on, which I'll go into again in more detail in my submissions, are unique and distinct and have specific requirements if I could take your honour to page 449. This again, the distinction is clear in the terminology used by the draftsman in the part 53 claims 449. This part sets out the special procedure for dealing with small claim issue. So I cannot stress that distinction enough. And at 53.9, it stresses the form, which is for the special procedure, which is P5301. That's on page 451. And then there's this express provision as to which parts do apply of the CFI procedure at 53.7. So it's all been very carefully, which is at page 450 of the bundle. So actually, it's all been very carefully put out in the rules. But what is interesting and what is important for the purpose of the application today is there is no, despite all that thought and the way that it's all been locked and put together, there is no mechanism to transfer from the SCT a claim without issuing and invoking the Part 7 RDC procedure, which involves issuing a fresh claim. And then the option.
I'm sorry,
Yeah.
can you take me? That was specifically, you were taking me to 53.42, I think, is really the basis for that submission.
Yeah, 53.41, which is the fresh claim and the procedures followed by, under the procedures followed by the CFI. It says a fresh claim under the procedures followed by the CFI, not the SCT, or not continuation of a claim from the SCT. It says a fresh, the use of the word fresh, I think, literally sets out that this is a fresh new start. And the use of the word new claim again illustrates that this is a claim that is not transferred by way of continuation, as
So
is argued for.
Where is the word new?
So I apologize. I think it's just the word fresh. I'm sure I've seen the word new somewhere, but I may be mistaken. I'll take you to it if I find it. But so in that context, and I'll develop this. Although I've set out the main submissions here now, so I won't go through it in too heavy a manner as we go forward, because I think once these major points are outlined, you don't need to keep going back and repeating them. So 53.41 should be read with 53.42, and 53.42, which is the important point, which is to pursue its claim in the CFI by filing a Part 7 claim form. What then that means is that you look at Part 7, which is at page 468 of the bundle, and that sets out very clearly how to start proceedings. So the reference in the SCT to Part 7 and the RDC in the CFI by issuing or filing a Part 7 claim form, Part 7, how to start proceedings. Clearly, you follow to page 468, which is then Part 7. That's the next logical step. And then it says how to start proceedings. So the two fit very well together. It's telling you, go over to Part 7 and start a fresh new claim in Part 7. It's not saying, and you have, and what's important, I think, at the point is the liberty at 53.42. It does give you the option. It says, if you want to, you have the option now. We've made the transfer, so I'm not arguing against the mechanism of the order and the transfer. I think that's only half the story. So there is this mechanism for transfer, but at that point where the option arises, then it's a new, fresh claim. The claimant has the option, shall I pursue this claim or not? If I'm going to pursue the claim, look at 53.42. In order to pursue that claim, and it says it in words clearly there, pursue its claim in the CFI by filing a Part 7 claim. The Part 7 claim is at page 468, and that provides, and it's quite interesting to look at that, which I think we can all accept at 7.1, its own unique mechanism for starting Part 7 process. And then if one looks at, then just finally, just so we can sort of
the possible, what has to be reconciled, and the the difficulty that I have is coming back to the point that your construction of these rules and of the order gives no meaning to a transfer. You treat it simply as a dismissal. The claim is gone on your, and I think it has to be on your submission. And your submission, I think, for the limitation point, is you say that the claim commenced in the SCT is at an end. It's finished, it's gone, no longer exists, and all the other things that the Monty Python team said. And what then happens is, if the claimant, files, pursues its claim by filing a Part 7 claim, that is a different claim. Now, there is tension both at a conceptual level and a linguistic level. At the conceptual level, as I've said, it gives no meaning to transferring the claim. Rather, it treats it as if the rules have wrongly referred to transfer and they really mean dismiss. Secondly, 53.42 says pursue its claim, not start a new claim, not says pursue its claim. So there are difficulties, I think, how I reconcile these various provisions.
No, sorry, if you finished, you want to take
Yes,
No, I understand, but I think I can answer your Honour's concerns. We don't say that the transfer is in any way a meaningless mechanism. We say it's an administrative mechanism that is available to the court, having made a decision in that the SCT does not have jurisdiction. Now, I think the fine balance, and I hear the points that you made, the fine balance here is you may then say, well, what's the point of it then? What's the point of the transfer if you're not going to transfer it to CFI? What I would submit is that that's a fair point, but then if one then goes deeper digs a bit more, the next mechanism which exists with the liberty to pursue is the mechanism which essentially what the transfer says is this claim that you bought in the SCT can be bought, or you can bring the claim in the CFI if you choose to under the CFI mechanism. So actually, when I'm explaining it, to a large degree, there is a redundancy to the whole transfer mechanism, because you are still required to issue a fresh new claim under the rules. And so therefore, I don't think that what this issue has obviously arisen in the context of this case, and we've drilled down into the detail of it. But I don't, and maybe there's been lots of transfers without thought going into exactly what that means. But now a light being shone on the transfer, or what transfer means and what the rules allow for, and whether there is in fact a mechanism of continuity, which is what the claimant suggests. In my respectful submission, the answer to that has to be a clear no. There isn't this mechanism of continuity. There is a mechanism where a court can dismiss a SCT claim because it lacks jurisdiction. There is a mechanism where the court can then offer the party an election to pursue the claim under the CFI if it wishes to under a fresh new claim. But really, what is the effect of that? It's not really any effect at all, because the claimant in that instance can go and issue a new CFI claim anyway. But what it does not do is preserve, unless expressly stated, any limitation period. And I think that's where there's a slight tension in the rules.
That might, in some instances, cause a great injustice, may it not? For example, the SCT may transfer a matter from the SCT to the CFI, not because the claim was not within the jurisdiction of the SCT, but having regard to the matter set out in 53.41, it is appropriate to transfer it. But on your construction of the rules, if a claimant commenced his claim within time, and then there were proceedings, matters then went on in the SCT, and there was a hearing and reserved decision, and eventually the court made an order, the SCT made an order transferring it to the CFI. And if by that time the limitation period expired, on your construction of the rules, the claimant would have become statute barred, even though he'd properly commenced the matter within the SCT, was within jurisdiction, and it was in effect a discretionary or value judgment by the SCT to transfer the matter. But in your construction of the rules, bad luck. He's statute barred through no fault of his own.
There are a couple of points. I hear what Your Honour says, and again, to a large degree, I agree with a lot of what Your Honour says. But each case has to be looked at upon its own circumstances, and I think
that can't affect the construction of the rules.
No, of course it can, but I think that what's important here in the context of this case is that if there are such exceptional circumstances where there is a potential injustice, in my respectful submission, the mechanism that exists at the SCT stage where the claimant was aware of the deadline, in the context of this case, the claimant was aware of the deadline. It was incumbent not on the defendant, but on the claimant to raise the issue before the judge, before Judge Nasser, and say that the issuing of the SCT claim form was by me in error on the 15th, or whatever explanation, and he's never tried to give an explanation for it. And the fact is, the limitation period was on the 18th. I invite the court to make an order, or invite the court to exercise its mind to disallow or deal with the limitation deadline that had applied on January the 18th. Now, in the absence of such a submission, or an absence of such a consideration by the court, in my respectful submission, to construe the rules so widely as to say that there is a transfer per se of an existing claim also lends itself to potential injustice the other way, which is that then if a party issues an SCT claim form strategically, knowing that the deadline is coming up for a limitation period, a party can issue an SCT claim knowing that the jurisdiction is not the correct jurisdiction, but that will be in effect an act which stops the clock, the limitation clock. So that in itself could lead to injustice for those that have the benefit of a limitation deadline.
Why would that lead to injustice?
Well,
the point of limitation periods, generally it's so that a defendant has notice of a claim within a reasonable time, so that because otherwise it will have conducted its affairs for some period of time without knowledge of it. The evidence will have gone stale, and so on. In the case of the employment law, there's an additional consideration arising under Article 19 and the, in effect, penalties for not paying up within the time you're supposed to. Now, when once the claim is commenced, none of those factors come into operation, whether it's commenced in the SCT or the CFI, the defendant is on notice, and the period for Article 19 purposes is not any different. So I don't see why there's any injustice.
Yeah, I hear the point that you make, but what we would say in response to that is that in the circumstances of this particular case and the construction of the rules, the employment regime, as you rightly point out, is a distinct and particularly onerous regime when it comes to the deadlines, not just for the sake of the employers, but the sake of the employees, and the requirement for certainty when bringing claims. Now, the 6 months limitation, and I believe it's only 3 months in the UK, the 6-month limitation is strictly adhered to. And in the context of an employer's expectation,
well, except for the Article 61 claims where there is a discretion to extend.
Indeed, yes, there is a discretion.
But under the Article 10, you're right, it's a strict.
It is, and in the particular circumstances of this case, where the claimant elected the SCT, we would submit that he was then putting himself in danger of that jurisdiction dismissing his claim. And it's not dissimilar to if a claim is dismissed in one aspect, it doesn't mean that the claim can then be pursued with a new limitation period. Once the limitation period has expired on the 18th of July, it's expired. Now, it was open to the claimant at that point to have 2 horses in the race, so to speak, by having issued his SCT claim, and this is why I took you through the background facts very carefully, that to put in a protective claim in the CFI on that period between the 15th and 18th, when he knew that the jurisdiction was going to be challenged. And so that goes to construction, but that goes to election as well. So in these circumstances, the claimant is the author of his own misfortune in selecting the SCT jurisdiction. It doesn't in some way increase or extend the time for him to be able to issue the claim that he needs to issue. The claim has to be issued on the 18th or by the 18th of June, unless there's some other discretion.
Well, perhaps we should go back to the question that has to be asked. The questions under Article 10 and Article 61 of the employment law.
Sorry.
Okay. Under Article 10 and Article 61 of the employment law, the relevant question is whether, I haven't got it in front of me at the moment, but I think it is whether the claim was presented to or brought to the court. Now you are, I think, aligning or eliding from that to a claim form was issued. So the question is whether the claim was brought to the court or presented to the court. And there would seem to be, I think, from your submissions, you accept, indeed it's the premise of your submission is that the claim was brought to or presented to the court by commencing the proceedings in the SCT. So that is right.
I think the point's made in my learned friend Scare's argument on this point, and I think it says under the relevant rules. Now, what we would say here is that the distinction, a claim being brought under the relevant rules, there's a distinction. And again, it's a matter of construction. The relevant rules in this case were that he chose the wrong rules. The relevant rules for him, given the quantity of the claim, was the CFI. And I'll let you.
All that Article 10 says, Article 10 of the Employment Law, is a court shall not consider a claim under this law unless it is presented to the court, either during the employee's employment or not later than 6 months after the relevant employee's termination date. So the requirement is that the claim is presented to the court. There's no requirement about relevant rules or anything of that sort. And similarly, then under Article 61, that refers to, what does it say? The court shall not consider a claim under this Part 9 unless it is brought to the court before the end of the relevant period. Again, so those are the questions. And as I understand your submission, your case is, yes, it was brought to the court within the 6 months, but the claim ceased, died, ceased to exist, perished, came to an end on the order of the SCT. And that's the end of it, because you say the issue of the claim form was the commencement of a new claim, was outside the 6 month period. And so that's the end of it. So the critical part of your argument is that the order of the SCT judge, say, brought to an end the claim, ceased to exist after the order was made. I think that's
no, that is right. So when the when the claim is the fresh claim, and this is where you will need to very carefully, and I hope you honour's got the point in relation to Part 7 strict rules, the Part 53 RDC saying that it's a fresh claim, saying that it's been transferred to the CFI in accordance with 53.4, liberty to pursue the option by filing a Part 7 claim form. The Part 7 claim form that's filed is a fresh new claim, and there isn't a, this is the point, this is the difficulty I think for the court, and difficulty I'm having too, there isn't a mechanism or a bridge. The use of the word transfer in the context of the Limitation Act is not sufficiently defined or sufficiently clear for the court to say, for the purposes of the application today, that there is a transfer of the cause of action or of the claim, thereby preserving the continuity. The issue date for the CFI claim form is the 25th of July. That's the issue date. That's when it starts. That's when the court is seized of it. That's when all the RDC provisions come into play. 7.3, 7.4. A claim form is issued on a date entered on the form by the court. So the claim that is before the court today, that Mr. Linstead is arguing for, we say, is a claim that is one that should have been issued back in June, on June the 18th. And the circumstances, and this is why I highlight the circumstances, it was open to the claimant to issue a protective claim.
Yeah. So in a sense, the contest is whether, as you put it, on the order for transfer, the claim that had been presented to or brought to the court ceased to exist, or on the other hand, whether the claim was transferred to and continued, and that, sorry, was transferred to and thereafter pursued in the CFI under the procedures now applying to it and the CFI, so that all of the rules referring to a fresh claim form and so on go to procedure, but not to the substance of the claim. I put that inelegantly, but those seem to me in conceptual terms, and perhaps something neither of you would be aware of, but at the back of my mind, I think of the procedures in Australia where there is a federal system and the matter can be commenced in the court of one state and transferred to another court, to the court of another state, and thereafter is pursued. I'm avoiding the word either commenced or continued because that assumes the answer, but thereafter pursued under the rules of the court to which it is transferred. And it's always been considered that the relevant commencement date for limitation periods is when it's brought in the first court. Now, that's dangerous because it's an entirely different regime, but it's those sort of concepts that are in, seem to me to be the competing concept with the one that you put forward, Mr. Purdon.
No, I hear that, and I think that, but I think that this is why I was very careful to take you through the circumstances that led to the issuing of the SCT claim, because we are very much making the submission that in this instance the claimant knew that it was not. But
that can't affect the construction of the rules.
No,
if you're right, it seems to me, if you're right in your submission about the construction of the rules, it doesn't matter what was in the mind of the claimant. It doesn't matter, for example, if he had acted promptly in issuing his claim within a short time of the termination of his employment. And it doesn't matter whether he was otherwise without sin. On your submission, seems to me, if the court transfers the claim, then that's it, bad luck. Your claim comes to an end, thereafter comes to an end, and if the limitation period has expired, bad luck, you're statute barred.
That's right. Yeah, that is the effect. Yeah, and I think that if one looks at the rules and page 469 of the bundle, and I think we've already taken you this to this particular article 7.8, article 7.8. Parties proposing to start a claim which is approaching the expiry of the limitation period should recognise the potential importance of establishing the date of the claim form was received by the registry and should themselves make arrangements to record that date. So, and at 7.5, limitations talked about.
That all assumes that after the transfer of the claimant is starting a claim.
Yes.
If he's not, then those rules have no application.
Absolutely. If he's not starting a claim, that's the end of the matter. Yeah. And so what we say, and I think I've made the point, is that the court should very carefully look at the construction of these rules to determine whether and there is, and we say the burden is on the defendant to establish, so the claimant to establish that the limitation period has not expired on the 18th of June. And it's for the claimant to establish, and it's attempted to do so, but without, understandably, without any...
Well, I have to say, you've skillfully dragged me into the question of whether the claim should be struck out because it's statute barred, which I said to you at the beginning I didn't think was part of your application.
Well, there you go.
And I don't know then. Anyway, there are two questions. First question, is it part of your application? Is it open to you to argue it on this application? And what alerted me to the fact that we were there was your reference to the burden. Ordinarily, if I recall correctly, the burden is on the defendant to show that the limitation period has expired. Now, of course, it depends. There are all sorts of different limitation periods, and as we know, sometimes they operate as a defence, and if so, it's for the defendant to raise the defence and then to make it good. In this case, it's a particular, the limitation period goes to the jurisdiction of the court to hear the matter. And I'm not sure that you're right in saying that the burden is on the claimant to show that the limitation period has not expired. You might want to tell me why,
Well,
rather than saying yes, it is.
we do say it's part of our application today.
Yeah.
If I could take you to page 73, you'll see submissions that were filed on the 21st of December by Mr. Sig on behalf of the defendant. And if I could then take you to paragraph 35, which is at page 81. The point is in issue, and it's one that the claimant should and is aware of. To paragraph 35, there ought to be strict adherence to the rules to provide certainty, consistency and predictability and avoid satellite litigation, especially where it is open to the defendant, as is the case here, to raise a limitation defence. Given the claimant's mistake, given the claim form was not dispatched in time within the 4-month period, it's argued by the defendant that the substantive, it's the use of the word substantive there, the substantive limitation period has expired.
Well, 2 points there. To see what the application is, conventionally one goes to the application notice, not the submissions in support of it. And the application notice seems to me confines your case to, if I can put it, the proper service of the claim form point. You do not. So if I look in part A of the application notice, the applicant intends to apply for an order that 1, a declaration pursuant to the rules of the court, Rule 12.2, I pause to say I think that should be a reference to 12.1 subrule 2, that the DFIC court should not exercise its jurisdiction which it may have in respect of the claim. I pause there to say that the claim that the court has no jurisdiction would be a claim for a declaration under 12.11 that the court has no jurisdiction, not a claim that it should not exercise its jurisdiction. Anyway, you go on in the application to say 2, an order that the claim form is set aside pursuant to Rule 12.71 or Rule 9.56. 3, an order that the claim is struck out pursuant to RDC 4.16.3 because there has been a failure to comply with a rule, namely, again, the service rule. 4, the defendant's costs. So, stop there. Doesn't seem to be any claim that the court should declare it doesn't have jurisdiction because the limitation period has expired. Secondly, when I go to your submissions, I think fairly a claimant would read those submissions in the knowledge that, or in the context of what the claim, of what the application is. And then 35 follows on, I think, essentially from submissions saying how the rule, that is the service rule, I think, should be applied, how the rules generally should be applied, and that there ought to be strict adherence to the rules to provide certainty and so on. And the reason for that is especially where there is a limitation defence. So that's giving a reason why the rules should be construed in the way you put them. And then it's in that context that comes a single sentence. Given the claim form was not dispatched in time, it is argued by the defendant the substantive limitation period has expired. Now that is a very obtuse way to introduce a claim that the claim should, sorry, an application that the claim should be sorry, I'll start it again. An application that the court should declare it has no jurisdiction because the limitation period has expired. And I can well understand a claimant not perceiving that that was an application made, even if, but I go back a stage where I started. Isn't the relevant fact that your application notice makes no reference of it? And you can't, can you, introduce new claims by putting them in your submissions, or new applications by putting them in your submissions?
You're right. Once again, I find myself agreeing with a lot of what you said.
Careful, careful, I often get it wrong.
No, but there is, once again, there's a distinction that I would invite the court to draw. My first point is that the claim form has to be looked at in light of any other document that may go in support of the claim or application notice. But what's distinct in this case, and I think this is where the difficulty arises, that in the context of an employment issue with a very tight limitation deadline, and I accept there's no express reference to the passing of the substantive employment deadline in the application notice, but the reference at page 81 to substantive limitation period, the knowledge of the claimant in the context of this case to the substantive limitation period, it's not an obscure contract or tort case where people don't know about the limitation period. Everybody in employment knows what the deadlines are, including the claimant. And so once the court is seized of this issue, and we say the claimant was always seized of this issue because he issued his initial claim 3 days before. He was very astute as to timelines. He issued once the court issued the claim form, in July, the very last day for serving it was 24th of November. He served it on the 24th of November. He's a lawyer. He knows these timelines. He works within the jurisdiction, and the subsequent, where there's reference to substantive limitation period, yes, arguably it should have been spelled out in the application notice, but in the circumstances of this particular case, and in some cases it must be and it needs to be, in the particular circumstances of this case, everybody is aware that the limitation issue that expired on June the 18th is an issue. It is an argument. In fact, what lends me to understand that the claimant does understand that this is an issue is the fact they've dealt with it in their submissions and their evidence in arguing for this form of continuity from the SCT to the CFI. So in the circumstances, they're not prejudiced. In fact, they've been able to put their only and best case forward, which is that there's this principle, doctrine, whatever you want to call it, bridge of continuity, which preserves the limitation period. In my respectful submission, in the absence of any clear law or any clear rule that they can point to that says that pursuant to such a transfer, limitation is preserved. And I don't know whether you need to go as far as to say in the employment context, but in this case, it's certainly in the employment context where timelines are sacrosanct. In that instance, that's the reason I made the submission. The burden is on them, and the best that they've been able to come up with. And in my submission, it's not enough to argue that the June 18th limitation period was somehow extended. Is that the transfer by Judge Nasser, using the word transfer accordance to the rules, was sufficient for there to be this continuity of limitation. And in my respectful submission, the rules, including the employment rules, do not allow for that. And if the court were to order that today, it would create an artificial situation where it is preserved. And in the context of this case, and that's why I keep coming back to it, particularly in the context of this case, where the claimant elected knowing that the SCT was the wrong jurisdiction. So if there is some discretionary power to make that decision in relation to continuity, and in my submission, in the absence of a clear rule or statute or RDC rule or legal provision, then the only thing that is open for the court is to exercise some form of discretion to say that there was a transfer, the continuity is preserved in the circumstances of this case. You need to examine the entire circumstances of the case, but this case falls down because of the conduct of the claimant knowingly pursuing the wrong claim. And in addition to that, he had 3 days, whereas a lawyer, and I'm sorry to keep stressing this point, he knew that his limitation period was up. So it was open to him, on top of all the other problems that he's caused for himself, to issue a protective claim within the CFI on the 16th, 17th, before the 18th or on the 18th, and see what happens in the SCT. And then his position is within the Limitation Act. So in my respectful submission, the rules have to be construed narrowly and correctly as the rules. And what they say is what they say. If there is some sort of omission or lacuna within them, it's not for the court or Mr. Linstead or the claimant to try and fill that in by saying, well, it's a sort of almost shrug of the shoulders, isn't it? There's a transfer, it must have transferred over to the CFI. In fact, when you examine it, it's completely opposite.
Mr. Perha, you've clicked over your 2 hours. I appreciate that I have taken some of your 2 hours with my questions and steering you in directions. What I propose to do is to give you another half hour in which to finish, and I will try to restrain myself to let you present your arguments as you see fit in that time.
Your interventions have been very helpful and hopefully have helped move things along. And so I will try to speed through as quickly as possible. Would you want to break now for 5 minutes, or should we just?
No, I'd rather you finish your submissions and then we'll take a break.
I'm grateful. I'm just checking, because I think we've covered
Yes,
a large part of what I needed to in. So if I now move on to the CFI claim form and the issuing of the CFI claim form out of time, which is the other issue that is, or arguably the main issue, as far as Mr. Linstead would say, that's before the court. I think I can go through that quite swiftly, because the interpretation of the rules there, we say, is quite clear, and there is no grey area in relation to those rules. 25th of July 2023, the claimant filed the CFI claim form, page 37 to 38. We've already seen that, and it was subsequently amended on the 22nd.
So, Jenny, I thought, I might be wrong on this, but I've got a recollection that I read the claimant said he didn't file the claim form, the court issued it without his intervention. I think this was in the second statement that's been entered in, and
And so actually I can make one of the points that I was going to make in relation at the highlight points I was going to make. We only discovered this information last Thursday in terms of the involvement of the registry and what the claimant says the registry did and did not do. The submission that I was going to make is that in the shortness of time, and I don't think it would have been an exercise or money well spent where we undertook inquiries and said we wanted adjournment to find out whether this really happened so we can find out facts in disputing that. But we do question those facts that the claimant puts forward about registry's role.
Well, I don't know how I can deal with that. I have given permission for the witness statement to be relied upon. There are the claimant in his witness statement gives evidence of those matters. There is no evidence to contradict it. On the face of it, it is not wildly improbable or fanciful. And so I can't see any basis on which I could reject what the claimant there says.
Again, I think that's a fair point. And so I think in those circumstances, what I would contend for is I don't seek to argue against you on that point. I think that the deadline, we say the mechanism doesn't really make a difference, and it doesn't assist on point one that I was just dealing with either in terms of saving the limitation period. But the date certainly is the 25th of July, and I think all parties accept that the deadline for service was the 24th of November 2023.
Yes.
Now, the RDC in relation to service of the claim form on the defendant is once again quite clear, and it's RDC 9.2, which is at page 477 of the bundle. So rules about service, part 9, and then 9.3, when a document is to be served by electronic means, the party who is to be served or his legal representative must previously have expressly indicated in writing to the party serving that he is willing to accept service by electronic means. Now, we say that that's quite strict, and what the claimant is arguing and seems to be arguing, which I can cut to the chase, is that because you may have accepted or dealt with an acknowledgement of service in the SCT using an email address, that is sufficient in the circumstances for me to have agreed with you that electronic service is good service. Now, what I point to here is, and again, it's one of the reasons that I highlighted the manner within which the claimant has brought this claim and pursued this claim, is that he failed to agree that in writing. So having been aware of the challenge to the SCT jurisdiction and actually know from the outset when he issued that claim in the SCT on June the 15th, it wasn't agreed by the defendant, without seeking to confirm with the defendant that it would accept email service in accordance with the rules. The service that he undertook, again, at great risk on the very last day available for him to serve, was incorrect. And so he missed the deadline again. And we don't accept that service was good on November the 24th. in the manner that's been suggested by the defendant. The email that he puts forward as the one that he used, that had been used previously in the entirely different SCT regime, is not an email that is a personal email or monitored regularly. And for the defendant the claimant to simply assert, well, that is the reason for good service, in my respectful submission, is woefully inadequate. In the email from the registry to dates, I think this is the email that I was going to refer to. It's page 208 of the bundle. It's quite clear. I think it's helpful to look at this. So this is from the registry. Dear sirs, thank you for using the e-filing system to file your Part 7 claim form with the DIFC court. So again, actually, this is another point on the continuation for your lordship to ponder over when you're making those considerations, is that it's clear that what's issued from the actual registry itself is essentially a new claim, and the standard format and wording is there, and it's made quite clear. You must now serve your Part 7 claim form on the defendant in accordance with Rule 7.20 of the DIFC rules. And the Rule 7.20 is at page 472, which says quite clearly, 7.20, after a claim form has been issued, it must be served on the defendant by the claimant within 4 months after the date of issue, where the claim form is to be served within the DIFC or Dubai. So the 4-month period was clear to the defendant. So the claimant.
The real issue here is whether service was effected under 9.31, having regard to 9.31A and 9.32B. And in particular, the provisions you've pointed to says that if you want to serve by electronic means, the party who is serving must have expressly indicated in writing that is willing to accept service by electronic means. And you say, well, he hadn't. The claimant says 9.32B says the following shall be taken as sufficient written indication for the purpose of subparagraph 1. B, relevantly, an email address set out on, relevantly, a response to a claim filed with the court. So that's the argument, isn't it?
Yeah. So I think the argument there, the argument is that the acknowledgement of service is sufficient, yes, to engage that particular mechanism. And what we say is that the acknowledgement of service in the context of the SCT claim, which is what is relied upon by the claimant some months back, is not what is meant by a response to a claim. And what the claimant is attempting to do is to try and clutch on to any response, knowing that it hasn't complied with the rule, and the response being the acknowledgement of service, and saying that because that was set out, the email was set out within that, when it was never the intention that that should be the formal correspondence or corresponding address. He's saying that that should suffice.
I don't understand what you're saying there. You're saying it was intended that that should be the formal address for correspondence. You filed your acknowledgement of service and stated that your address for service was that email. That is, documents to be served on you were to be served by being sent to that email address. That's what the acknowledgement of service says, is it not?
In the context of the SCT
Yes.
claim.
Yes.
Yes. Yes. So I accept that. In the context of the SCT claim, that is what was said. I think that has to be, I think the better point and the point I'm trying to make is that has to be balanced in the new fresh CFI claim and the RDC rules, which are distinct, that commence under Part 7, which were directly pointed out to the claimant, that in the context of the rule, and I think this is where the balance comes into it, the rule saying that you must obtain in writing in the context of a fresh new claim, weighed up against the the claimant's assertion that reference to an email address in a previous response is sufficient to satisfy the court. In my respectful submission, that's not right, and it can't be right. And what I would say is, it may be helpful just to look at this. There's not many case authority that I want to take your lordship to, and I'm mindful of the time. But the UK Supreme Court authority of Barton versus Wright Hassel LLP, page 382. There's a very helpful commentary.
So what page is it in the bundle?
Sorry, page 382.
Ah. Yes, I have it.
And it's not a particularly lengthy judgment, but actually what's quite helpful within just the summary at the start, if you turn over to page 382 and B, if you go down to B, and then it starts, but that, so they suffer by validation, but that expire, so if you can get to but that, although necessary, that the claim form be brought to the defendant's attention, that not necessarily that the claim form be brought to the defendant's attention, that although necessary was that was not sufficient, that rules of court had to identify a formal step which was to be treated as informing a defendant of the contents of the claim form. That had to be a bright line rule, clear and precise, so that the exact point could be determined from which time limits ran for the taking of further steps in the action and for any limitation period. So the point that I take from that, which I would expand upon, is this bright line rule. Here we have a bright line rule, which is that you should agree in writing before serving by email. And then what you have is...
But you're overlooking that's not the totality of the rule. The rule goes on to say that will be sufficient. It will be sufficient if I haven't got the words in front of me, but you've got to go. You're referring to 9.31a, but you've also got to go to 9.32b, which says, now what page will be on? 477, I think it was. If I can find that again.
Yeah.
477. So 9.32 says the following shall be taken as sufficient written indication for the purpose of subparagraph 1. And we go to B, an email address set out on a response to a claim filed by the court. So if the claimant can bring itself within 9.32b, that's sufficient. You can't, if 9.32b is satisfied, we're not concerned with whether there was otherwise some express indication in writing and so on. 9.32b is sufficient. So the question is whether that rule is satisfied. And as I understand your argument, is one of two things, either or both, that an acknowledgement of service is not a response to a claim filed with the court, and secondly, a response to a different claim filed with the court is not sufficient, and the acknowledgement of service in the SCT was acknowledgement of service of a different claim than the one in the CFI. That's what I understand your arguments to be.
Yeah, yes. I think what would be helpful here is to look at the arguments that we did make, so I can just be clear. Page 76, if you would, which were our submissions in the SCT. Oh, sorry, CFI submission on the application is yeah, 21st December. So if I could go to page 76, paragraph 14, RDC 9.3, where a document is to be served by electronic means, the party who is to be served as legal representative must previously have expressed that. We've been through that, so that's great. But paragraph 2b, a fax number, email address, or electronic identification set out on a statement of case or a response to a claim filed with the court. And if you go to paragraph 16, this is where we make the distinction. The position will vary depending on who is affected service and by which type of electronic method. But the relevant sentence is at the bottom. An acknowledgement of service is not a statement of case, as it is not.
Let me stop you there. The claimant doesn't say it's a statement of case. It says it's a response to a claim.
But RDC 9.3b is a fax number, email address, or electronic identification set out on a statement of case or a response to a claim filed with the court. So I get your honours relying on the second part of that being the response to the claimant.
That's what the claimant relies on.
So what we say in response to that is that a response to a claim filed with the court in the context of the acknowledgement of service, and I think your honours just summarised the point that we make, so I don't think I need to make it again. I think the point at our highest is that a response to a claim being a previous claim or another claim, an SCT claim, is not sufficient when interpreting the rules, particularly the strict interpretation of the rule in relation to get approval of email service if you're going to issue a claim.
That's what I've understood your case to be.
Yeah. So the point is, we say acknowledgement of service is not strictly a response. It's a response in that you're replying to somebody with an acknowledgement, but it's not a response like a defence or a counterclaim or a reply pleading. Is an acknowledgement actually a response? It's a form of response, but is it strictly response? I think your honour's got my point, so I don't want to labour that, but we say that it's really in the whole context of the claim and the manner within which the claimant has handled it, which we invite the court to take into account. We say that this flouting of this particular or the disregard of this particular rule is symptomatic of the claimant's disregard for rules in general. And by taking a huge
presupposes that there's been a disregard to the rule. That is, that the condition is not met, which is the first argument.
No, well, that's right. I think that's right. I think what that does bring into play is the seriousness of signing a statement of truth, not knowing it to be true, in weighing up all of the
that's a different point. Well, you've made that point.
No, but weighing up subsequent conduct, subsequent actions, in my respectful submission, the court has to take into account the whole picture to understand exactly whether or not in this circumstance it was an innocent mistake or there was there was some explanation behind it, or it's reasonable in the circumstances for the
I
claimant.
understand that. I understand that argument to be relevant in this sense, that you say that the condition in 9.32b was not met, and then the claimant's position over is, if it was not met, it was a procedural irregularity, and the court should make an order that it is effective notwithstanding the procedural irregularity. And you say, no, it shouldn't, for the reasons you've just told me. But those reasons are not relevant to whether or not 9.32b is satisfied.
I agree. Yes.
The claimant's motives and so on are irrelevant to that issue.
Yes, that has to be right. It has to be right.
Yeah.
A response to a claim filed with the court. It's for the court to ascertain whether it feels that the AOS is sufficient in the circumstances, argued as a response. So, Your Honour, my other submissions, I'm conscious of the time, it's 2 hours 31. The other submissions, I think, overlap to a large degree with what I've already dealt with.
Well, I have read them all as carefully as I can, so it's not necessary to repeat anything that's set out in writing. I will have regard to everything that's set out in your submissions and your skeleton argument.
I'm grateful, Your Honour. So I'll stop there and allow Mr. Linstead to go on. Thank you for listening.
All right, thank you very much for your submissions. What I propose to do is to take a break. Now, I'm not sure what sort of arrangements that you have in mind. I had in mind a break of either 15 or 20 minutes, something of that order, not long enough for anybody to have lunch or breakfast, lunch or dinner in our respective cases, but enough for you perhaps to attend to some break and a glass of water or whatever. With that in mind, Mr. Linstead, without holding you to it, would you make a guesstimate of how long you think you might be?
An hour and a half.
Okay. Well, would 15 minutes be satisfactory to you both?
Yes, that would be enough.
All right. Well, it is now, I think, 2:27, let's say 2:30. We'll resume at 2:45 Dubai, which I think is 10:45 for you, Mr. Linstead.
Yes, thank you.
We'll break and resume then at those times. Thank you. All right. I can see both Mr. Perha and Mr. Linstead are back. So let us proceed. Mr. Linstead, over to you.
I'm going to make 4 broad submissions as outlined in my skeleton argument. Firstly, that there's no breach of the service requirement in RDC 9.3 because the defendant did indicate a willingness to accept service by electronic means within the rule. Secondly, if the proceedings were not correctly served, the court should exercise its power to remedy that defect under Article 5.41. And then thirdly, on limitation, and I'll address you on the issue as to whether it's before you when I get there, but on the limitation point, if we are dealing with it, the claim was presented in time for the purposes of the relevant limitation provisions when it was issued in the Small Claims Tribunal, was then transferred to the Court of First Instance and did not need to be reissued. And then fourthly, in the alternative, the court should exercise its discretion to extend the time for the purposes of bringing the discrimination and victimisation claims. Now, all of that is set out at paragraph 22 of my skeleton argument. I'm going to begin by going through the documents and taking you to points which are of particular significance. I'll then begin with the service point. Before I do that, I begin by making the observation that the point the defendant takes on service is an entirely technical one. There's no dispute that it received the claim form and particulars of claim on the 24th of November 2023. That's admitted. It's admitted at paragraph 37 of the defendant's skeleton argument, lest there be any doubt about that. And so there is no prejudice at all to the defendant in this situation in relation to service. I'm going now to go through the documents, bearing in mind that they're relevant both to the limitation issue and to the issue about correct service. So we're really dealing with both at the same time. In terms of the chronology, there's no dispute that the employment terminated on the 19th of December. The first important document then is the claimant's claim form in the SCT, and that's on page 3. And I would like to take us back to that. Now, the point I draw out of that is that the defendant is given an email address, so the claimant has identified the defendant's email address on page 3 as dubai@kbh.ae. The first time that email appears, because of course it was the same one that was subsequently used. On the same claim form, at page 6 is a reference to the value of the claim, and that's where the defendant has made much of the claimant's statement that all parties have elected in writing to proceed in the DIFC Court's Small Claim Tribunal. It's accepted that that was not accurate when it was set, but it has to be seen in context. The context is important. The first important part of the context is that the section of Part 53, which deals with the SCT jurisdiction, which I'll come on to in detail later, but for now, we don't need to look at it. That the rule does not require that the election is made prior to the claim being issued. I'll come back to that. The other part of the context is important, is it's very clear the claimant issued his claim with the hope and the desire that agreement would be obtained from the defendant for matters to remain in the Small Claims Tribunal. And to illustrate that point, I need to take you back to the claimant's submissions prior to the jurisdiction hearing in the SCT. So if I begin at page 23 of the bundle, and paragraph 48, that's where the claimant acknowledges that there is no formal correspondence from the defendant expressly confirming agreement that these proceedings be heard by the SCT. Now, that statement by the claimant undermines the defendant's suggestion that the claimant was involved in a scheme to mislead or abuse the court in some way, because very shortly after issuing, he's made very plain to the court what the position is. And so if there was an error in what he said initially, he has corrected it here. He also sets out in this document his strong desire, for want of a better word, that the defendant should agree to that position. And he goes on in great detail to the reasons why that is in everybody's interests. So I need then to take you to paragraph 27, sorry, page 27. And we're looking at paragraph 68B. And this is where he's setting out reasons why he says the matter should be dealt with in the SCT. And B, he refers to embarrassing and sensitive matters in relation to health, medical, private and family matters, which will be in the public domain. So he's concerned about publicity potentially for his own personal issues. At C, he refers to adverse publicity and likely media coverage involving lawyers and law firms. Talks about the defendant initially, but then in the final sentence at C, he says, in the event the defendant is or claims not to be phased, the claimant wishes to safeguard himself and his career against adverse publicity. Going on to E, the claimant is not afraid to admit that he has legitimate concerns for his career development and reputation in the event these proceedings are transferred to the CFI. Professional standings, reputations, and integrity are an intrinsic part of a lawyer's success in the DIFC or the UK. And then going on to paragraph 73, he reiterates, I won't read the whole paragraph out, but he reiterates the fact that he's relatively new in this employment. And he says in the third line, he's at risk of being thought of less favourably as an employee in the job market, both here and in the United Kingdom. And then going on to paragraph 78, in his conclusion, he says, even if the quantum exceeded 500,000, it would be reasonable in the circumstances and the interests of the parties to both agree to submit to the SCT. So in summary, what the claimant is doing here is two things. He's doing his level best to avoid his case being put up into the public forum of the Court of First Instance. And he is behaving entirely legitimately in trying to do that. And he's giving very clear reasons why. For example, the confidentiality of the SCT is something which would favour him, and he says also the defendant. And the other thing he's trying to do is to persuade the defendant that they should consent to the jurisdiction, and that's paragraph 78. He's inviting that they both agree, to use his words. Now, inviting the defendant to agree is not an abusive process. And so even if his reference on the claim form to an agreement can be criticised, it has to be seen in that context where it's very quickly corrected. In any event, what we say is that comment is of no relevance to the jurisdictional issues that this court is concerned with. It doesn't affect the issue of the proper interpretation of the rules as to service or the proper interpretation of the rules as to jurisdiction. It is neither here nor there. Now, that is all the context of the claim form. I'm going to go on to the other documents. Carrying on the chronology, the next thing is the notice of service sent to the defendant by the registry attaching the claim. That's at page 11. I can quickly take you to that. The key point there is that document also identifies the same email address, dubai@kbh.ae. And then the next document is page 202. And that is the email from the court, which attached that notice of service. It's the top of page 202 going on to page 201. But you can see that the court is using that same dubai@kbh.ae email address on the 15th of June. And the other point, of course, to note is that when the court served it on the defendant using that address, the defendant immediately responded, and they copied in the claimant when they did so. So that's at the top of page 201. The defendant's response, obviously saying they're going to contest jurisdiction, but also the claimant is copied into that as well. Now, the next part of the chronology is that the claimant paid the court fee in the Small Claims Tribunal, In the interest of time, I don't need to take you to that, but we've got the receipt. No doubt you'll have seen it in reading the papers, confirming his payment of a fee of $4,857. That figure is significant because it is commensurate with the value of the claim. It's a high court fee because it's a high claim. And it's also significant because it's the only fee the claimant paid. He didn't pay, wasn't required to pay any court fee in the CFI. They specifically told him he didn't need to do so. So he's issued once and he's paid one fee. I do need to take you to the next document, which is page 203, which is the defendant's acknowledgement of service in the Small Claims Tribunal. And of course, the key aspect of that is over the page at 204, where under their identification, who is submitting this document, they give the email dubai@kbh.ae, the same one that's already been in play. Now, also, it's relevant to the factual matrix that then became the basis of correspondence between the parties and the court. So just one example of that is page 205, a couple of pages on, where we can see that on the 14th of July, the court sends an email to both parties, but it uses that same dubai@kbh.ae address. The next thing in the chronology then is the hearing before Justice Nasser Al Nasser on the 14th of July. And as you've already observed, the order was that the claim shall be transferred to the Court of First Instance. We've already looked at that document. Those words are very clear. I don't need to take you back to the document in the bundle at this moment. The next thing that happened is, according to the claimant's witness statement, and this is paragraph 13. Again, it's clear that you've read that, Your Honour. I don't need to take you to it right now. But the claimant visited the registry to ask about the transfer and to ask what was happening. And he was told he didn't need to do anything, as well as being told no further court fee was payable. I then take you to page 208, which I would like you to look at. And that is the email that he then received from the registry. It's actually a claim form. I emphasize that the first paragraph of that email, where it says, "Thank you for using the e-filing system to filing Part 7 claim form," that is incorrect. And the claimant's statement has made it very clear that this is obviously a standard letter, but in fact, he hadn't filed a form on the e-filing system because it was something that the court generated. The claim form itself then is at page 37, and I would like you to look at that. And that, as we know again from the claimant's statement, is a claim form that the court has generated of its own accord by taking, it would seem, the details from his SCT claim form and transferring them. And that includes the defendant's email, which is once again referred to at dubai@kbh.ae. It includes the amount of the claim, which is referred to there as $242,000. And as the claimant says, evidently the registry itself has converted the dirham value into dollars for that purpose. Then, very importantly, on page 38, under the section Law Governing the Dispute and Law Giving Rise to the Jurisdiction, what the court has entered for law giving rise to jurisdiction is the words transferred from SCT 228 2023. So whatever the rules say, it's actually embedded in the claim form and entered by the court that the only reason the claim is here is because it's been transferred. Moving on in the chronology, I'll simply mention at this stage, the next thing that happens is the registry approved an amendment as to the value of his claim. We don't need to look at that, but the amended claim form is in the bundle, excuse me. It's in the bundle at page 39. And the claimant then lodged his particulars of claim. The next document is page 210, which is the crucial email from the claimant where he served the proceedings on the defendant on the 24th of November. And we can see that he served it on that same email address, dubai@kbh.ae. He also served it on the addresses of 3 other KBH personnel, which had appeared in the previous correspondence. One of those is the address of Bushra Ahmed, who had personally emailed the court when it was in the SCT. But the key address we're concerned with, of course, is the Dubai@KBH one. And he attached to that particulars of claim and the CFI claim form, and indeed an amended version of the SCT claim form. What then happened is the defendant filed its second acknowledgement of service, contesting jurisdiction. We don't need to look at that immediately. Now, that takes you through all the key documentation, which I'll come back to refer to its significance. I come back to the claimant's first argument, which is that the service by email was done in circumstances where the defendant did indicate a willingness to accept service by electronic means on a response to a claim filed with the court. I'll take you straight to the relevant rule. I know you've already looked at it with Mr. Perrar, and the rule is at page 863 in the bundle. That appears to be the rule as set out in my skeleton, but it's no worse for that. We can see that the full rule is there. A document at 9.2, a document may be served, and 9.24 by means of electronic communication. 9.3, where it's to be served by electronic means, a party who is to be served must previously have expressly indicated in writing to the party serving that he's willing to accept service by electronic means. And then the key points are at 2, where I've highlighted certain passages for which I make no apology. The following shall be taken as sufficient written indication. And then at 2b, an email address or electronic identification set out on a response to a claim filed with the court. I'm missing out the words that don't immediately apply here. That's what's relied on. We've seen the acknowledgement service. I know that Your Honour is alive to precisely what the point being taken about that is. And the simple argument is that the acknowledgement of service clearly is a response to a claim in the way that it is defined. In my skeleton argument, I've set out why it falls within that definition. And we're looking at paragraph 13 of my skeleton. The reasons relate to the wording of the rule. There's no dispute that the AOS is not a statement of case. Quite obviously, a response to a claim, whatever it means, is different from a statement of case. So, for example, it's clear that response to a claim doesn't just mean a defence, because defence would fall under the description of statement of case. So it must mean documents other than a defence. the rule only requires that the email address is set out on a response. It doesn't require any express statement by the party that it will accept service by those means. And then the rule is broadly drafted, and I emphasize the fact that it refers to a claim, not the claim, and that we say is wide enough potentially to cover an acknowledgement in the SCT proceedings. That's particularly apt in these circumstances where the same claim was transferred from the SCT to the CFI. Now, of course, I'll go on to look at that issue in detail, our case that it was the same claim being transferred from one to the other in the context of limitation when we get there. But we say that that's the only proper interpretation. But also, importantly, it was the claimant's interpretation. And this is really developing paragraph 13F of my skeleton. The claimant reasonably regarded this as a continuation of the same proceedings, and he was merely sending it to the same address which the court and the defendant had been using. And it's clear from his witness statement in this matter, his first witness statement, that that's his position. I'd like to take you to that. Firstly, page 110 in the bundle. Now, I've gone there because it's the beginning of a section where he goes through the history of the means of service of documents and the use of email. So that begins at paragraph 26. And that section carries on through to paragraph 34. Can I take you then just to paragraph 31? And I do that because that's where he specifically refers to the acknowledgement of service in the SCT. And he says that the defendant responded, and he notes that within that response was the email address due by at kbh.ae. And that document was then served on him by the registry. So he's made reference to it there. And the point I'm making here is this isn't just a lawyer's point. The point I'm making about him having been provided with the address is consistent with what the claimant was actually doing at the time. I then go on to page 112, next page in his witness statement, and particularly paragraph 36. He says, despite the defendant's attempts at mischaracterizing the otherwise, I was aware of the provisions of RDC 9.2 and 9.3 when I served proceeding to the CFI. However, what the defendant fails to acknowledge and is evasive about before the court is the fact that these proceedings are indeed simply a continuation of proceedings from the SCT that were already live and have been in existence since the 15th of June. The case is not one that's brand new to the JFC courts, even upon its arrival in the CFI from the SCT. Were the contrary true, the claim would have been time barred. Now, that's important because it shows he was aware of the rules and the statutory limitation. But he's taken what I would ask you to find is a perfectly reasonable position based on what the rules say that the claim is transferred. And this contradicts the defendant's suggestion, certainly made in the skeleton argument, that this was in some way a willful or a flagrant disregard of the rules. That's not the position. Now, that is the totality of my submission on correct service. And I ask you to find that it was correct to serve for that basis. But the defendant makes an alternative, sorry, the claimant, forgive me, makes an alternative submission, which is that if the proceedings were not correctly served, the court should exercise its jurisdiction under Rule 4.51 to remedy that defect. And I need there just to look at what the rule says.
Do you need to bring a separate application for that?
What? I don't need to bring a separate application. And the reason is because the claimant is entitled to say to the court, there has been no breach of the rules. That's his primary position. And in those circumstances, it wouldn't be right for him to be applying to the court for relief. And that is his position. But then as an alternative, in dealing with the application, he's entitled to say that if the court finds otherwise, that they should exercise his discretion. So I say, given the nature of him responding to this application and the basis on which he responds, we're not dealing with a situation where he needed to put in an application notice in relation to 4.51. Now, if I'm wrong about that, there's an aspect of the rules which helps me here, which is RDC. It's actually 23.3. Now, unfortunately, it's not in the bundle. I have to rely on the court's indulgence there. I see everyone is reaching for their copies of the rules, so I'll do the same.
Yes.
And 23.3 is the provision on application notices. Um, 23.2, the general rule is an applicant must file an application notice. 23.3, an applicant may make an application without filing an application notice if this is permitted by a rule or the court dispenses with the requirement for an application notice. There is certainly provision for you to dispense with any need for an application in this case. And I say this is an appropriate situation for that because it's not the claimant's primary case. He simply says, if I'm wrong, I'd like to ask for relief. And that is the normal way for these kinds of proceedings to be dealt with. Now, just before we leave that issue about application notices, the claimant has at least indicated his intention, and before I was involved in this case, in his first witness statement, to make this application. It's in his first witness statement, specifically paragraph 14. Your Honour may be familiar with that. I'll take you to it if you want to see it, where he says in terms that he can rely on 4.51. But that's what he said at the outset. And it also makes the point, of course, that the defendant is not taken by surprise because this position was set out at that stage, and they're very much in a position to answer it. And indeed have answered it in their submissions. There's no prejudice to them. So that's my alternative application. And I need to make a few points in support of that. Firstly, there are a number of DIFC authorities which support using 4.51 specifically for relief if there has been a defect in the service of the claim form. I begin with a case called DIFC Investments against ZIA. And I'll take you for now to page 653 in the bundle, where we can see that case. I apologize for the fact that it's a very small text in the transcript. That's the beginning of the case, and we'll have to, in fact, go on to the second page. And I'm looking particularly at paragraphs 17 and 18. Now, the background in the DIFC case is that the claimant was found to have breached a mandatory service rule, which is 9.29, which required that when a claim form is served outside the DIFC, it must be accompanied by a certified Arabic translation. Defendant also in this case contended that he wasn't familiar with English, so there was some prejudice. I need then to read paragraph 17 in the judgment in response. Now, they set out rule 9.29, and in the second sentence, it is undisputed that the defendant was served in 2 locations outside the DIFC, and that there was no accompanying certified Arabic translation. of the claim form included in service. 9.29 is a mandatory rule, although there is nothing to suggest the defendant is not able to waive this requirement by accepting service and responding to the claim. We then go on to paragraph 80. It reiterates the claimant failed to comply with 9.29 and did not provide the required Arabic translation when attempting to serve the defendant. The claimant makes no significant objection to this fact, but argues that the conduct precluded him from objecting to the form of service. However, this conduct may amount to a waiver of objection began on the 8th of February. Now, just to be clear, what the court then does is to say that they will use the power in 4.51 to remedy the defect. So it's found a defect. And it's the final sentence that makes that clear, paragraph 21. Therefore, it's appropriate to remedy these procedural errors in the above mentioned manner pursuant to the power granted me by 4.512. The same paragraph makes the observation that neither party has been prejudiced in the proceedings. Now, 2 points come out of the Mohammed Zia case. Firstly, it's clear that the provision can be applied even if it's a breach of a mandatory rule. And secondly, that it can be applied to a defect in a claim form. It's not defect in service of other documents. And those are two important points. There is some further support for this position in a subsequent case called VIH Dubai Palm Jumeirah against Assas Opco. That is a case which you'll find at 697 in the bundle. I can ask you to quickly look at that. And we're looking at paragraph 159 in the judgment. And the background here is this was an application for committal against 44 defendants. And the submission was made that an application notice was required. Sorry, forgive me. The submission was made that a claim form was required to start the proceedings rather than an application notice. So it was an allegation of failure to file a claim form. The essence of the decision, you see at paragraph 159, is that the judge disagreed with that. So at 159, at the bottom of the page, says the non-party respondents contend that pursuant to 52.4, VIH should have started separate Part 8 proceedings against each of them. This failure invalidates VH's committal application. I reject that submission. But the judge then says, at the end of the paragraph, even if there had been a breach of RDC 52.4, the court would have rectified the error under RDC 4.51. Since, in my opinion, no injustice resulted from the manner in which VIH proceeded. So that is a judgment of Justice Sir Richard Field. Again, making it clear in the same circumstances that a mandatory rule relating to a claim form be dealt with by that. Now, I accept that 4.51 is not specific to claim forms. It's a general provision. I do, though, also make the point that the rules of the DIFC don't contain the same provisions, the same wide provisions that exist in the English civil procedure rules for remedying defects in claim forms. I've made this point and set it out in some detail in the skeleton argument, but there is a particular aspect of this to emphasize, which is that if I take you in the bundle to rule 9.31, and that's at page 483. there is a provision there for service by an alternative method, where it appears to the court that there is good reason to authorise service by an alternative method not permitted by these rules. Now, there is an identical provision in the English CPR, which is CPR 6.15.1. But the English courts had ruled that that does not have retrospective effect. So the court can't use the provision, certainly according to the English jurisprudence, to remedy a defect which has already happened. And for that reason, the English CPR were amended by adding 6.15.2, which applies that provision retrospectively. That amendment hasn't happened in the DIFC, and I make that point because
it's subject to Article 61.2. So what does 61.2 say? Let's go back to 61.2.
there seems to be some interference. I make this point to emphasise the fact that the breadth of the provisions available to provide relief in the DIFC rules are not as wide as those in the UK. And just there is an authority just confirming what I've just said about the manner in which the English rules were amended, which is in the bundle, which is a case called the Good Law Project against the Health Secretary. I don't need to take you to that authority, but in order to just emphasise that what I've said about the history is supported by exactly by what's said in that case. It's referred to in my skeleton argument at paragraph 22. And just for the court's reference, there is a mistake in the skeleton because when I referred to the Good Law Project, I referred to paragraph 60. And it should have said paragraph 22.
It should be paragraph 22.
It should say paragraph 22, Good Law Project.
It's a coincidence that that appears in paragraph 22, is it?
That's pure coincidence, yes.
All right.
Again, I'm not in interest of time. I don't need to take you there, but that's where the reference is. Now, this supports firstly the point that where there is a general provision of this nature, it could be applied to a claim form. And we've seen the DIFC decisions in which that has happened. But secondly, to emphasize the point that if you can't just look at English authorities on defects in claim forms and read them across because they are applying different rules. I accept English authorities can be helpful on some occasions, but they have to be read with that caution. Now, having said that, 4.51 is identically worded with an English provision, which is CPR 3.10. It does the same thing, and there are English cases in which 3.10 has been used to salvage defective service of a claim form. I'm just going to take you now to one of those. Which is the case of Dorian acquisition against Ionis Frangos. And it's page 735 in the bundle, which I'd like you to look at. And that's paragraph 76 of the Dory case. Now, this is simply the judge in that case. And I should, by the way, just give you the background facts. This was a case involving a defect because the claim form wasn't sealed and didn't have a claim number on its face. And this was an application for relief, given that it was accepted that it wasn't therefore proper and wasn't correctly served. Para 76 sets out broadly how Rule 3.10 would apply. And I'm looking at 76.2. CPR Rule 3.10 is a beneficial provision to be given a very wide effect. It can be used beneficially where the defect has no prejudicial effect to the other party and to prevent the triumph of style over substance. CPR Rule 3.10 can apply even where the defect constitutes a failure to serve sufficient claim forms on defendants, or a failure to deliver the correct claim form to the correct defendants, or even where the defendant received no claim form at all, only an acknowledgement of service form in the context of service of claim forms on multiple defendants. Moving down to 3, in view of this broad guidance, the most important question determining whether CPR 3.10 applies is whether there has been an error of procedure which might otherwise invalidate a procedural step. This would be more difficult where there's been, for example, a complete failure of service. And then at 4, another important factor to consider is whether the defendant has suffered any prejudice as a result of the procedural error. The court has, in the past, used its powers under 3.10 to remedy service of an unsealed claim form without a claim number, where the service of that claim did not deprive the defendant of any knowledge of the fact that proceedings had been or were about to be started, or the nature of the claim. So that's the guidance. And then very briefly, if we look at how that was applied in this particular case, but if we turn forward to paragraph 96, page 740 of the bundle, we can see reference to the guarantor and Waterson Hicks have long been aware that Doré Acquisitions intended to start proceedings. I'm jumping forward now to paragraph 98. The guarantor has long been aware of the contents of the claim form and the allegations made against it. And then 99, the guarantor did not suffer any prejudice as a result of the error of procedure. I'm not going to read all of it again in the interest of time, but one can see the degree of prejudice and the degree of knowledge of the defendant is one of the central considerations. Now, the reasons then we say that RDC 4.51, which is identical to that 3.10, why that should be applied in this case, I've set out in my skeleton argument at paragraph 20. And the essence of it, of course, is that all the documents were received by the defendant. They don't dispute that. They filed an acknowledgement of service, which demonstrated the fact that they received them, and they suffered absolutely no prejudice. They had, in any event, been using the same email address to accept service of the proceedings in the Small Claims Tribunal. And then a final point, 20E, an important one. The defendant isn't prejudiced in the sense of losing a limitation defence if you exercise your discretion in the claimant's favour here, because the defendant's case is that limitation had already expired. So there isn't, it's not going to affect them in that respect. They say limitation isn't relevant in this context. And that would be a classic reason why a defendant might say that they suffer prejudice, so that the discretion shouldn't be exercised. But that doesn't apply here. Now, because we're asking you to exercise the discretion in this alternative argument, it is relevant to point out that the defendant has breached the rules of the court in various respects in these proceedings. I'm not going to dwell on this point, but I emphasize the reason I'm making it is, to the extent a discretion is being sought, and to the extent the defendant is relying on procedural breach by the claimant, the defendant itself doesn't come to court with clean hands. And that is, in a discretionary arena, that is a relevant factor.
If your hands are a bit dirty, so are theirs.
That is certainly one way of putting it.
Right.
I'm not going to dwell on this. In terms of the points I make, they are evidenced in the bundle by one email from the claimant sent on the 22nd of December, where he sets out the fact that he hadn't been served with the defence acknowledgement of service, which is a breach of a mandatory rule, and he hadn't been served with his application notice, which is a breach of a mandatory rule, and he hadn't been given prior notice of this application when it was sought to be an application on paper, which is also a breach of a mandatory rule. Those are examples. We've also seen the exceeding the paid limits case arguments. Now, there are various breaches, and I don't suggest that they are comparable to an error with a claim form, but nevertheless relevant to your discretion. I make no more of that point. Two subsidiary points now, which I'll deal with very quickly. First of all, and this is paragraph 26 of my skeleton, the acknowledgement of service in the CFI could potentially, we say, be seen as a waiver of the relevant defect. And I say that because that was the approach of the court in the Mohammed Zia case, where we've already seen the reference to that and been taken to the paragraph. And then another point in terms of your discretion is that there is another provision available to you, potentially to give relief here, which is to make an order dispensing with service. And that is the power available under 9.34 of the rules. And I will just very quickly take you to that. Which is in the bundle at page 484. Now, we've got there 9.34. The court may dispense with service of a document, and 9.35. An application for an order to dispense with service may be made without notice. So taking us back to the question of whether we needed to make an application, potentially this is an application being made without notice. But it is another route by which the court could come to the same conclusion. I don't need to say any more about it, because I say there's no practical difference between the effect of that or the effect of 4.51. Now, at this point, I'd like to just briefly address the authorities that the defendant has relied on in support of its application in relation to the service point. I'm going to refer only, I think, to 2 or 3 of those. The first of those is McAlpine against Richardson Roofing. And I'm going to begin taking you to page 441 in the bundle. Now, the background to McAlpine is that the judge was only here dealing with the first issue we've dealt with, which is whether service was valid in the first place. And this was where the defendants had put in a notice of acting. And the argument was made that the notice of acting was a response to a claim. So they were relying on the same wording in effect that we're dealing with the DIC rules. Of course, the notice of acting was put in because the defendant had changed solicitors. The key point in this case is paragraph 22. Oh, I should perhaps begin at 21. It's the bottom of page 441. And we can see that the judge says, Mr. Suri makes the point that because of the formality that attaches to the notice of acting and its similarity in form to an acknowledgement of service, as it were, this is a document to which the court should pay particular attention in trying to ascertain whether there has been an indication in writing. I'm afraid I do not see that. It's perfectly true that it is a court form and it contains an email address, but it contains a fax number and telephone number as well, one cannot really read into that any more than that these are the totality of the contact details for the solicitor. After all, the point in relation to this document is not about service. So those two paragraphs show this judge specifically contrasting the notice of acting, which wasn't enough in that particular case, with an acknowledgement of service, which by implication could be enough to fall within the relevant provision of Part 9. So that I say that directly supports our case. I then refer to the Supreme Court case of Barton, which I believe my learned friend referred to earlier on. We're going to begin, I think, at page 390. Now, Barton was the case involving a claimant person litigating against a law firm who had served by email without permission. That's obviously why the defendants rely on it. There was no dispute, though, that it was invalid. So it's different from this case in that respect. This was all about an application to validate service retrospectively. What I emphasize about the Barton case, even though it's Supreme Court, is that it doesn't lay down any new principle. It was simply a discretionary decision by a district judge. And the issue on appeal is whether it fell within the ambit of the judge's discretion. And just to emphasize that point, I'd take you to paragraph 15, page 390. Says Mr. Barton is appealing against a discretionary order based on an evaluative judgment on the relevant facts. In the ordinary case, this court wouldn't disturb such an order unless the court making it had erred in principle or reached a conclusion that was plainly wrong. In my opinion, both the judge and the Court of Appeal identified the critical features of the case and reached the conclusion they're entitled to reach. So that's the extent of it. In essence, they're saying the judge was not wrong. Could I then take you quickly to page 387, same judgment, paragraph 9. What constitutes good reason for validating the non-compliant service of a claim form is essentially a matter of factual evaluation. It does not lend itself to over-analysis or copious citation of authority. So that's saying we look at every case on its own facts. And comparisons with other cases are not necessarily helpful. So to summarize on the Barton case, it is not authority for saying that service by email in a non-compliant way can never be retrospectively validated. It's not saying that, even though that was the decision on the particular facts. And in any event, the Barton case was controversial. The decision was made by a majority in the Supreme Court. It was a 3-2 decision. Enough said about that. I then very quickly want to take you to one more defendant authority, which is the case of Abella against Badarani, another Supreme Court decision. And I take you to page 363 in the bundle. And paragraph 33. Now, this is talking about exercising the discretion under Rule 6.15.2. So to reiterate, that's the provision that does not exist in the AFC rules. However, insofar as it refers to a discretion, then I do rely on it. And it says the question is whether the judge was entitled to hold that there was a good reason to order that the delivery of the documents was to be treated as good service. Whether there is good reason is essentially a question of facts. I don't think it's appropriate to add a gloss to the test by saying that there will only be a good reason in exceptional circumstances. And then jumping down page, it says it seems to me in future under Article 6.15.2, the court should simply ask whether in all the circumstances there is a good reason to order that steps taken to bring the claim forward to the attention of the defendant is good service. So it's got to be a good reason, not exceptional. That's all I'm going to say about those English cases. I then want to move on to the second limb of what the defendants are saying today, which is the limitation point. It's right to say that this application did not include the limitation point. It's not there in the application notice. The claimant's position is that it is prepared to deal with this issue. Clearly, we've made argument on it, and that would avoid, apart from anything else, the issue having to be dealt with on a subsequent occasion. But I do note, and again, talking about procedural failings, it's a matter that should properly have been raised when the application was raised, and it wasn't. And I'd also reiterate the point I think that you made, Your Honour, which is that it's not apparent from the submissions made with the claim form that the point was being raised at any stage prior to the second witness statement of Mr. Singh in these proceedings. But I'm not going to labour that, and I'll address it now. So, in terms of limitation, the place to begin, it's not in dispute that time started to run from the date of termination of the employment, which was the 19th of December, and that the latest date, therefore, to bring a claim would be it's either the 18th of June or the 19th of June 2023. I say there are two different dates because the wording of Article 10 and Article 61 is slightly different. It's not material for your purposes to need to go into that because in either event, the claim had to be brought by the 19th, and it was issued in the Small Claims Tribunal on the 15th. So that there's no dispute about that. Of course, in my skeleton argument, as you will have seen, I've broken down exactly how the limitation periods apply here, but there's clearly no dispute about any of that. I don't need to go into that now. What, of course, does matter is the wording of the two provisions, and I will just quickly go back to those. So beginning with Article 10, that is at page 445. A court shall not consider a claim under this law unless it is presented to the court not later than 6 months after the termination. So the key words are presented to the court. And then jumping forward to the discrimination provisions, Article 61, that's at page 447. And the wording there is at little 2 is unless it is brought to the court before the end of the period of 6 months. Now, I just pause there a moment. Those words are key. They're active words, and they involve somebody, in this case the claimant, either bringing or presenting something to the court, and that's the wording which must apply. Now, I'm at this stage going to make 3 propositions, which are really the basis of the claimant's position on limitation, and they're very simple. The first is the claim was presented to the SCT within the statutory limitation period. Secondly, the occasion, and the only occasion, when he brought or presented a claim to court was when he issued his claims in the SCT. And then thirdly, having brought that claim to the SCT, the same claim was transferred to the CFI, where it continued. It did not begin again. Now, beginning with the first one of those, that the claim was presented to the SCT in time. The first point is, from the point of issue in the SCT, it was a properly constituted claim, which was capable of being heard in the SCT. And this is, I'm really now developing the material around paragraph 56 of my skeleton argument. We then need to look at the small claims rules. So it's 53.2, it's at page 449. That says the SCT will hear and determine claims within the jurisdiction of the DIFC courts. 2, where the claim relates to the employment or former employment of a party, and all parties elect in writing that it be heard by the SCT. Bracket, there is no value limit for the SCT's elective jurisdiction. So that's the provision we're dealing with. Now, that provision, which says the SCT will hear and determine where all parties elect in writing, does not require prior election. It simply says they will hear and determine claims if all parties agree. If it were otherwise, we would expect this rule to say a claim may only be issued if all parties elect in writing, or it would say, when it refers to an election, all parties elect in writing at the point of issue. But there's no such restriction. And that's for a very good reason, which is that it's entirely reasonable and feasible for a party, particularly one who has a big claim, to be approaching limitation and needing to file a claim, and then to subsequently seek to get the agreement of the defendant to that matter being dealt with within the elective jurisdiction. And that's a point, Your Honour, that I think you made to Mr. Perrott earlier on this morning. It follows from this, there's no difficulty in principle if a party does that. They issue an employment claim under employment claim over 500,000, and then all parties subsequently agree to the SCT being the relevant jurisdiction. And clearly, in that case, a defendant couldn't go back and say, "Well, you didn't issue in time originally." So the question is whether the tribunal has jurisdiction at the point of issue. Now, in this case, at the point of issue, the question of election hadn't even been discussed. The defendants weren't to know that there was a claim over the 500k limit on the way. And so clearly it was a claim that could legitimately be brought for those reasons. There's clearly no requirement on a claimant to seek agreement prior to issuing, because if there was, the rule would say so. And then importantly, Mr. Perrott took you to Rule 53.4, which makes the point that a party can't withdraw without permission if it has elected in. So you can't withdraw from electing in, or at least not easily. But there's nothing to stop somebody who had initially refused, for example, changing their mind. You can't withdraw from electing in, but there's nothing to stop you from withdrawing from electing out. Now, my interpretation of this rule is also consistent with the nature of the Small Claims Tribunal, which is that it's a jurisdiction set up to encourage and to welcome the early and economical resolution of disputes. And my interpretation of how this rule would apply is entirely consistent with that. Now, whilst we're on part 53, there are other rules to note. And first of all, it's 53.10. I can take you to that. Which says a small claim is commenced when the SCT registrar issues a claim form. Then 53.16, which says, and now we're now getting on to jurisdictional challenges, what happened here. The jurisdictional challenge must be filed at the time of filing the acknowledgement of service and must set out the grounds on which the party makes the challenge. And 53.18, the challenge must be heard by an SCT judge at a jurisdiction hearing. The SCT judge may decide the challenge within the hearing. Now, I've gone to those provisions because it shows that this whole process, including the jurisdiction hearing, is within the rules. So the claim having been issued, and whether or not some election from one party or the other happens subsequently, the claim remains a valid claim in the SCT throughout this, and it's dealt with by the SCT rules. The thing that potentially removes it from the jurisdiction of the SCT is, of course, the jurisdiction hearing, a decision at a jurisdiction hearing. And at that point, we need to look on to paragraph 53.41, which talks about reallocation. Now, we say the clue is in the heading. The heading in the rules is reallocation, not stopping and starting. But looking at the wording of 53.41, it says where appropriate, the SCT judge may issue a reasoned order that the small claim be transferred to the court of first instance to be progressed as a fresh claim under the procedure followed by the CFI. That we say clearly is an order for an existing claim to be transferred. It can't have any other possible interpretation. And then we need to look at 53.42. A claimant in an SCT claim that's been transferred to the CFI is at liberty to pursue its claim in the CFI by filing a Part 7 claim form. Now, sticking with point 42 for a moment, if the position was, as the defendant says, that the claim wasn't actually being transferred, the rule here would say the claim shall be determined and maybe begun again in the CFI. But that's not the wording. The wording is at liberty to pursue its claim, i.e. to pursue an existing claim by the filing of a Part 7 claim form. And the filing of that claim form is the means by which the matter is progressed. Equally, going back to the wording of 53.41, the wording is to be progressed as a fresh claim, not started again as a fresh claim. And the point being made with the words fresh claim is that this is a confirmation or a continuation where the procedures have to start again, the acknowledgement of service has to be sent again, and it makes it clear how the procedure is going to apply. But it's still using the word progression and pursuing as opposed to starting again. And so there's no question linguistically that what is happening here is a transfer of a live claim. And all these rules, we say, flatly contradict the defendant's assertion that, as they put it, at the point they told the registry that they didn't consent to the SCT's jurisdiction, according to Mr. Singh's guys an argument, they say there was no live claim. Well, clearly that indication of itself doesn't have that effect. It has no effect under the rules, and that submission is simply legally wrong. Now, before we leave part 53, I want to go to 53.81, which is the cost provisions that apply on transfer, because these provide an important important clarification. It's 4.6, sorry, page 461, 53.81. Where a claim is transferred from the SCT to the court of first instance, Rule 53.78 costs in the SCT will cease to apply after the claim has been transferred, and the cost rules set out in the RDC will apply from the date of transfer. Now, firstly, that emphasises again that there is a transfer of a single claim. But secondly, it makes the point that the CFI regime continues from the point of transfer, the costs carry on from the point of transfer, not from the date that a new claim is issued in the CFI. And the rule could have said that if that was the intention. All of that supports our position. There are other rules which allow the SCT, or show the SCT to is applying the same jurisdiction in effect as the CFI. In particular, 53.82, which says an order of the SCT shall have the same status as an order of the court of first instance of the DIFC courts and may be enforced in accordance with the rules and procedures set out in RDC 4550. And also 53 going backwards, 53.6, the SCT may grant any final remedy which the judge of the CFI could grant. So those are all consistent with a continuation between these two bodies, as opposed to what's suggested, which is an entirely separate and self-contained entity. Now, I want then to then look at the evidence. What actually happened on the evidence, and this is around paragraph 58 of my skeleton argument. What happened on the ground is entirely consistent with the rules, and this is now going to the claimant's second witness statement.
Except for 53.42, isn't it? In that the claimant didn't. What is 53 point?
Yeah. Yes. If that's correct, the claimant didn't file a Part 7 claim form. And it's quite right. There is a mismatch between the facts and what actually happened. I say, insofar as we've got that evidence about what actually happened, that is simply supportive of the claimant's position here, that this is regarded by everyone, and in particular by the courts and the registry, as a transfer of a live claim. So insofar as that rule wasn't applied in his case, and he was actually in effect invited not to apply it, because he went to ask what to do and they said, well, you don't need to do anything. All of that evidence just supports our case. But even if he had filed himself a Part 7 claim form, the wording there still supports us. So yes, that's a fair point, Your Honour. We've then got, and I could take this point very quickly, we've got the evidence and the wording used by the court. Of course, we've got the Justice's order of the 17th of July, the claim shall be transferred. We've got the wording on the claim form written by the court itself, which said transferred from the SCT. And then we've got the fact that the registry filled in the claim form, which is, again, I say entirely consistent with transfer. And the fact that there was no further court fee. So those are the facts. I then do want to look at Part 7, so I want to go back to the rules and begin at 7.5. So that's page 469. Now, this is an important provision because 7.5 and 7.8 uniquely deal with the issue of statutory limitation, but within the rules. So they're important provisions. 7.5 says, where the claim form as issued was received by the registry on a date earlier than the date on which it was issued by the court, the claim is brought for the purposes of limitation on that earlier date. Now, also highlight that this is the same wording as appears in Article 61, the word brought. This provision refers to the claim form being received in the registry, and it's that rather than the issue date which determines when limitation starts. It doesn't say received in the CFI, and of course there is only one registry. It is one and the same registry in this case, which is not surprising. So it was only received by the registrar on one date in this case, which is the 15th of June, when the claim was issued in the SCT. There's no other possible interpretation of that wording on the facts in front of you. We then need to look at 7.8, which is also about limitation date. Parties proposing to start a claim which is approaching the expiry of the limitation period should recognise the potential importance of establishing the date the claim form was received by the registry, and should themselves make arrangements to record the date. Now, clearly, if there's some internal transfer process between the SCT and CFI, that's not something a claimant has any part in. So the claimant can't note a date that happens, and it would be redundant from that perspective. The only date that the claimant could note, which would make 7.8 make sense, is again when he filed his claim at the registry for the SCT. I'd then like to go back to 7.3, which is where Mr. Parrar started his submissions. Proceedings are started when the court issues a claim form at the request of the claimant. That can't strictly apply here to the start of these proceedings, because the claim form, well, the claimant never did request the issue of a claim form in the CFI.
Although the rules contemplate that he would.
They do. But for the reason I've given under 7.5, even if he did request the issue of a claim form, or if he's deemed to have requested the issue of a claim form, that doesn't say anything about statutory limitation, because 7.5 tells us exactly what we should apply to analyse the correct limitation date. And it's saying we don't look at the issue date, we look at the date received.
That usually applies, one would expect that to apply in the situation with electronic filing, where the claimant has filed but not paid the fee, and the court and its claim form is not issued until a later time. That's principally what 7.5 is addressing, isn't it?
Yeah, that's clearly what it relates to. But it nevertheless, the language does have direct application to what happened in this case, we say. And in any event, we have the fallback argument that the claim was only issued once and the same claim was then transferred. But I'm simply giving a way through which allows us to apply these rules and say, yeah, well, we have actually come within the wording of the rules. That's in effect what is happening here.
Okay.
Now, the final part of our argument on this is that, quite apart from what the court said, or even what the rules say, the claim which arrived in the CFI from the Small Claims Tribunal was precisely the same one that had been issued in the SCT. The claim form in the SCT set out discrimination and victimisation claims, and it also included financial claims, which were separate from those, but still brought under the employment law. The claimant was clear about what those claims were, and as far as the financial part of it, in his submissions in the SCT for jurisdiction, he broke down in some detail what the financial claims were. Again, in the interest of time, I don't think I need to take you to that, but the references are all there in my skeleton argument. And it's that claim which then appeared in the SCT, emphasised in particular here by the fact that the court itself transferred the dirham value and turned it into a dollar value. I mean, there couldn't be clearer evidence of the same claim moving from one jurisdiction to the other. So that's all I need to say about that point. And I think I then move on to my summary of my argument on limitation, which is again in the skeleton argument. I'm not going to go through all of it, but I'm going to emphasize one or two points. So the summary is paragraph 76 of the skeleton. I'd emphasize point D. The point here is that the date on the date of issue on the claim form in the CFI cannot possibly be regarded as the date when the claim was presented to the court for limitation purposes. Because the claimant didn't actually do anything. So he didn't do anything that could fall within the wording of brought or presented, those active words within the employment limitation provisions. And also, the date of issue of the claim form is not a date over which the claimant has any control, which must be a factor, a relevant factor when looking at the interests of justice and when the limitation date actually is. He didn't know they were going to send him the email on 25th of July. It could have been any other date. And you couldn't possibly have a limitation date, which is simply not in the claimant's control. In any event, of course, we rely on clause 7.5, which says it's not about the date of issue, but it's about the date received. And then point E in my skeleton, I make the point that another date you can't rely on for limitation purposes is the transfer date between the two, the SCT and the CFI. Because in reality, there isn't any clear date when that transfer happens. It's all dealt with as an administrative process in the same registry, in effect, and that's all you've got to go on. But in particular, again here, the claimant didn't take any active steps to present or to bring at that point in time. Now, those are all my submissions on the primary limitation point. If the court isn't with me on that, then the defendant asks the court to extend the time for bringing his claim under the discretion in Article 61(2)(b) of the employment law. And I then just need to take you to those provisions and finally address you on that. So we're looking at page 447. And 61(2) said a court shall not consider a claim under this part 9 unless it is brought to the court before the end of A, the period of 6 months, etc., or B, where a complainant satisfies the court that there are circumstances which justify disapplying 61(2)(a), such other period as the court considers reasonable. Now, I begin by saying that the claimant has made his case as to why the court should exercise its discretion at the end of his second witness statement. I assume in making my submissions that you have recently read that, Your Honour, so I don't need to take you through that specifically.
No.
Before I get on to his particular circumstances, we need to look at what this provision means. There is no case law on it that I'm aware of in terms of the precise interpretation. All it gives you is a very broadly drafted discretion. It may be of some assistance to look at the equivalent English provision. There is a provision in the Equality Act in the UK, which is similar but not the same. And what that does is to say that there is a limitation period of 3 months, or, and this, I put the wording in my skeleton argument, paragraph 83, or such other period as the employment tribunal thinks is just and equitable. And again, it may assist to look at what the UK Court of Appeal has said is meant by that. And I just have one authority for that, which is, again, it's set out in my skeleton, so I don't need to take you to it, but it is in the bundle. And it's the case of Abatawi against Morgan. It's page 800 in the bundle, but I can look at the citation in my skeleton argument and paragraph 84. This says, unlike section 33 of the Limitation Act, section 123 does not specify any list of factors to which the tribunal is instructed to have regard. It would be wrong in these circumstances to put a gloss on the words of the provision or to interpret it as if it contains such a list. Dropping down 2 lines, the Court of Appeal has made it clear that the tribunal is not required to go through such a list, the only requirement being that it does not have it does not leave a significant factor out of account. That said, factors which are almost always relevant to consider when exercising any discretion whether to extend time are A, the length of and reasons for the delay, and B, whether the delay has prejudiced the respondent, for example, by preventing or inhibiting it from investigating the claims while matters were fresh. So in short, I don't suggest it's an identical provision. I don't suggest we can read over all the case law. I do say that approach is a good one to take here, which is 2 factors are likely to be central to your discretion. One of those is delay, length of and reasons for the delay, and the second one is whether the delay has prejudiced the defendant. Now, at that point, I'm going to take you to the arguments in the claimant's favour that I've made in the skeleton argument beginning at paragraph 85. Firstly, this is only a short, on the facts, this is only a short delay. It's between the 18th of June and the 25th of July. It causes no prejudice whatsoever to the defendant in the way it's suggested here, in terms of gathering evidence or otherwise. And also, we say there is a good reason for the delay, which is that the claimant had lodged his claims in the Small Claims Tribunal, and he knew that could go one of 2 ways. Either the matter would be heard in the Small Claims Tribunal, or it would be transferred to the CFI. But it was entirely reasonable for him to take that step and to take the view that he had issued within limitation. I'd also say it's arguable his view is correct. And if you were to decide against that position on limitation, the claimant shouldn't be penalised if the court takes a different view on that. I'd also say that it's not reasonable to suggest that he should have issued protective proceedings in the CFI once he knew that the defendant was saying that it didn't consent to matters being dealt with in the SCT. That would have on the facts that would have required him to issue a CFI claim form within about 2 days of issuing his original claim. And the reason that's
on one view, it might be considered an abusive process to commence another identical action.
Well, indeed, and indeed, the point he makes in his own witness statement is that it would be an inefficient use of the court's process. It's the same point you make, Your Honour, to be issuing 2 claims at the same time. And of course, wasteful costs, his costs, the defendant's costs, and the rest of it, which I mean that re-emphasises the reasonableness, I say, of the position that he took. But it wouldn't be reasonable to expect him to issue protective proceedings. Firstly, because he considered he'd issued his proceedings within a limitation, and secondly, because the mere fact that the defendant had said it didn't want the matter to be dealt with in the CFI didn't end the Small Claims Tribunal jurisdiction. The matter still had to proceed to a jurisdiction hearing, and he was still within his rights to try and persuade the defendant that they should go to jurisdiction hearing at that point in time. The final point in terms of exercising the discretion is that these are serious allegations. We haven't touched on them because it's not been directly relevant to these proceedings, but he brings allegations of discrimination and harassment and victimization relating to his religion and gender. And those allegations include him saying that he was required to work in excess of the Ramadan working hours, which are enshrined in Article 23 of the employment law. Of course, everything is disputed, but these are serious allegations, and the prejudice the claimant will suffer if he's unable to take these claims potentially to trial is very considerable, and that has to be weighed against the defendant's position. We say the defendant, apart from having to meet the claims, suffers no prejudice at all. In particular, its ability to find witnesses and the cogency of evidence won't be affected one iota by the fact that there would have been a 6-week delay. Those are my principal submissions. I'm not going to address you any further on abuse of process or the cases that the defendant has raised, because they really haven't addressed it in their submissions, and we say it's of no relevance to these matters. I'm just checking my notes, but I think that is all that I need to say to you. I will also just check my messaging system to make sure that my client, who is in Dubai while I sit in London, hasn't got anything else to say. Could I just have just a moment with my microphone off?
Yes, I'll just pause for a little while whilst you do that.
Thank you. Your Honour, my client is trying to speak to me. I'm just receiving a call. Could I ask for just 5 minutes just to see what that is?
Yes, all right.
Maybe we turn off cameras and microphones.
Yes, indeed. I'll put mine back on in 5 minutes and await your return.
Thank you. I'm noting it's 22 minutes past. Thank you.
Yes, Mr. Linstead, are you ready to resume?
Yes, thank you, Your Honour. I am.
All right.
I have no further submissions. I presume the others are with us. I can't see Mr. Perrar, but
not yet. I can't see Mr. Perrar there yet. but we'll both sit and wait for him to return, I think.
Apologies to keep
It's all right.
keeping you waiting.
Yes,
You're
Mr.
right.
Perhar, Mr. Lindstedt has just informed me that he has no further submissions.
Your Honour,
Do you
thank
have
you.
any submissions in reply?
I do. There's actually 5 points that I wish to make, and I'll try and take them as swiftly as possible. I'm mindful that we're over the 4 hours that Your Honour indicated at the outset. Your Honour, the first point that I wish to make is Your Honour made reference to Article 10 of the Employment Law, which is at page 445, and so has my learned friend. My submission is that construction is in fact not correct and does not take into account the entirety of the clause, which was missed out by my learned friend when he read it, and does not actually take into account Schedule 1 of the employment law, which I'm afraid is not in the bundle. So it's Schedule 1, Article. So Schedule 1, defined terms 3. If we look at defined terms,
Yes. And which defined term?
Cool.
Well, I have a hard copy of it.
You
Perhaps
do.
if
So
you
if,
read it. Yeah.
so if we read Article 10 at page 445, you do have that in the bundle first. So
Right.
subject to Article 61(2), a court shall not consider a claim under this law unless it is presented to the court either during an employee's employment with an employer or not later than 6 months after the relevant employee's termination date. So the point there is, if you look at the use of the word court, it's capital C, so defined, and that definition is what we don't have in the bundle. It's what hopefully you have a hard copy that you've indicated you've got there.
Yes.
So if we go to Schedule 1, and then it's at Part 3, defined terms, and if we go down to court, it expressly states any relevant court or tribunal established in the DIFC or in relation to any proceedings under Part 9 of this law, the DIFC Court of First Instance. So properly construed, Article 10, in the context of the reference to Article 61(2) and discrimination, is in reference to Part 9, which the discrimination provisions, which is what the claimant relies upon to bring his claim, as has just been outlined by my learned friend in relation to his claims of discrimination, victimization and harassment. So the point is, it's not about bringing proceedings to a court, it's about bringing proceedings to the CFI, to the Court of First Instance, in relation to discrimination claims under Part 9, which is what we are looking at here.
Yes, I see.
Thank
Well,
you.
That is a new point being raised for the first time in the reply submissions. I think I should consider the submission, but I will have to give the complainant an opportunity to respond to it. What I propose to do, Mr. Lindstedt, is to give you leave to file written submissions in relation to that point. What time would you require to do that?
Your Honour, I am ready to deal with the point now.
All right.
Instead of it being by written
Yes.
submission. And it is
Alright.
actually covered off in my skeleton argument.
Oh, is it? I had
Yes.
All right. Well, I'll wait and I'll let you have a rejoinder.
Thank you.
Yes, that was your first point. Thank you, Mr.
Thank you, Ronnie. If you want to, the second point is construing all of the rules together to give them effect in accordance with the law. Our RDC 9.32b, which we looked at, which is at page 477 of the bundle, and this is on the point a response to a claim filed with the court as raised by Your Honour and my learned friend. And the point that I make here is going back to construing the rules in the round. The rules have to be read with each other and with the law. There's just some sub points that I wish to make here. The AOS, the Acknowledgement Service in the SCT, and I already made this point before, but I must stress it, is not the same as an acknowledgement of service in the CFI. And I'll go on to qualify why it's not the same in a moment. This relates back to the point made that there cannot be a continuation for the reasons said previously. But the additional point in this context is this. So if you want to return to page 450 of the bundle and SCT 53.7. So extent to which other parts apply is the heading 53.7 to 53.8. The SCT, as we've already outlined, is a discrete process. It has a special procedure, as you will have seen and outlined at 53.1449. But staying at 53.72, what we say is the rules of service expressly set out there do not apply to SCT claims, save for 9.6, which deals with at paragraph 53.72, which deals with part 9.6 service of the court. If that is correct, then our submission is how can 9.32b apply to an acknowledgement of service filed in an SCT claim, because save for 9.6, none of the other rules apply. So we submit that that can't apply in the context of 53.7 and the restrictions placed therein on service within that clause.
But 53.7, to the as I understand, you make the point that the rules that in the RDC in relation to service do not apply in the SCT.
Yes.
But the issue is not whether service was effected of the claim form in the SCT. We're concerned with whether the claim form in the CFI was in accordance with the rules in the CFI. So for the moment, I don't see the relevance of the fact of the provision that the RDC in relation to the CFI do not apply in the SCT.
The point that we make with that is that the use or the attempted use of the acknowledgement of service, which applied in the SCT, which is what the claimant contends for, cannot be correct. And the black and white straightforward, where we use an acknowledgement of service as a response, that is not correct given 53.7.
Why? Is there something in 53.7 that says an acknowledgement of service filed in the SCT cannot be a response to a claim?
Yeah, the point, I think the point is what we're saying is that they're seeking to rely upon as good service an acknowledgement of service used in a CFI claim, which is a completely distinct regime of rules. And given 53.7 adds an extra layer and a gloss onto the fact that this shouldn't be permitted.
I see. All right.
Yeah, and when we filed the acknowledgement of service in the SCT, it was in pursuant in context of the SCT, which has entirely different service rules as set out there 53.7. So to say that you can rely upon them for the CFI when it's an entirely different forum and an entirely different service regime, we say that that shouldn't be permissible in the circumstances.
All right.
And the third point we rely upon is, I can be very short in this point. The claimant says, and he relied upon part 23.3 and said that the court can consider claims where there is no application notice. So we simply say, you know, what's good for the goose is good for the gander. If it's the case that the court thinks that there are matters that have been before the court that the court is seized of, that the parties did have an opportunity to submit on, then the court should and rightly should dispose of them if it thinks it's the correct thing to do.
Well, I propose to do that in relation to your limitation argument. Not, of course, in relation to your abuse of process argument.
I'm grateful. I do need to make one point, which I think I omitted to make before. In terms of the abuse of, sorry, the limitation points, we are reserving our position in relation to making substantive points on that. Should the matter proceed?
What does that mean? If I determine the limitation question against you, why isn't there an issue estoppel or some other form of estoppel against you? I don't think you can have it both ways. You either put your argument up and the decision, it seemed to me, is probably going to stop you one way or another, or you withdraw it and try to run it another day.
Well, I think that we, whilst setting out that we do make that express reservations, obviously it's open to your honour to make a decision that you do make, but it may be an issue that we raise in our potential defence, and I think we're entitled to do that. But obviously that may then be subject to something Mr. Linstead or Mr. Raof has to say about what your honour raised. But I am instructed to raise it in front of you to say that we reserve our position. All
right, as long as you understand, I'm not in any way endorsing your reservation of rights.
No, I wouldn't expect you to.
Right.
And then the fourth point is in relation to RDC 4.51, the court's general power to correct procedural errors. Now, I can keep this quite short. In the circumstance of this case, I think Your Honour is quite aware where the defendant, as a lawyer, has embarked on this process. We say by falsely signing a statement of truth that all parties had agreed to the jurisdiction of the SCT, which we say is an inescapable fact on the documents before the court. The claimant's counsel, Mr. Linstead, refers to cases which are entirely different circumstances and the authorities relied upon by the claimant in paragraph 18 of his skeleton argument can be clearly distinguished. They're cases that refer to incorrect translations. There are no material assistance to the court whatsoever. The court must look specifically at the circumstances of the facts in front of the court in this case, and those cases offer no material assistance. For example, my learned friend raises the case of Mohammed Zia, a breach of a mandatory rule. But the easy response to that is, but there may have been a breach of a mandatory rule, but it's not an intentionally false statement by a lawyer that knew about a limitation period and arguably misled the court to issue a claim in the wrong forum. It's just comparing two entirely different matters and trying to fit them in to say that where there's been an intervention.
I don't understand your submission that it misled the court to issue the claim form in the wrong forum. Let
me be clear. I think maybe that's not.
If that statement was not there, that wouldn't affect whether or not the court issued the claim form.
No, I think that's a fair point, Your Honour. I withdraw that. I think I've made the point in regarding the statement and the statement of truth. Yes. So I think that what we're saying is that you cannot compare the cases that an friend takes you. Just on this fourth point, finally, as to considering the English authorities, the court is invited to take into account what we refer to in case law in our 21st December submissions at page 77, which the court is entitled to do, which can be used to help interpret DIFC law. My learned friend.
What paragraph?
It's page 77. Hold on, I'll just go to it.
Yes, okay.
I think it's footnote 4.
Okay, thank you.
So, yeah, and which can be used to help interpret the IFC law. However, my learned friend referred to the Equality Act, and we submit that, and its recent case law has confirmed that English statutory law cannot be applied in the DIFC. So I invite.
Mr. Linson didn't submit that it could be applied.
That's fine. Okay, I just wanted to clarify that point.
What he said was, in effect, that that was the approach that the court took in those circumstances in relation to that legislation, and he submitted that would be, I think his words might have been, a good approach for the court, for this court to take in these circumstances in this litigation. No more than that.
I'm great. I think you are. I made my point on that, and
Yes.
thank you for that clarification. And finally, the fifth point, very quickly, Mr. Linstead asks the court to exercise discretion in the claimant's favour. I think we've made sufficient points on the conduct of the claimant to exercise the court's minds on that point. I'm very grateful. Thank you, Your Honour.
Thank you. Now, Mr. Linstead, I wasn't aware, at least in relation to the first point that Mr. Perha made. I mustn't have been concentrating when I read your submissions, because I missed that point. But so I will give you an opportunity, and indeed to assist me by telling me where that point is made, and anything else you want to say in response to that point. And indeed, if there are any other points made by Mr. Perha in reply, which you consider are not matters which you had a proper opportunity to respond to earlier.
Thank you. On that first point about Schedule 1, Paragraph 3 to the employment law.
Yes.
It's a paragraph 77 of my skeleton argument. 77
Right.
to 79, in fact. Where I've set out the same definition that Mr. Perha has just taken you to. Which, as we've agreed, is not in the bundle. So the definition of court, and I need to take you carefully to what it actually says. Any relevant court or tribunal, it says, established in the DIFC. So I note that the or tribunal part could include the small claims tribunal, or
yes.
in relation to any proceedings under Part 9 of this law, the DIFC Court of First Instance. So insofar as it's being applied to Article 10, which is the non-discrimination claims, the definition of court in Article 10 could be any court, any tribunal established in the DIFC, i.e. including the small claims tribunal. Insofar as it relates to Article 61, which is within Part 9, then it's referring to the court of first instance. That's what the provision means. Now, a couple of points in response. The first one is that these claims are not simply claims under Part 9. That is only, if you like, half of the claimant's claims to the tribunal. And he makes a number of financial claims for non-payment of various sums and a penalty, which are nothing to do with Part 9 and the discrimination provisions in the employment law. In effect, it's almost exactly half his claim, and I need to just be very clear why I say that.
Well, I think I understand that, but the point, if that's right, doesn't it lead to the conclusion that if I describe the claims that the claimant brings in his claim form, in the SCT and then again in the CFI, they can be described, I think you might describe them as the financial claims and the Part 9 claims. And is it your submission that so far as the claim relates to the financial claims, they were properly brought within the SCT, but that doesn't save the Part 9 claims, does it? The Part 9 claims must still be brought within the CFI.
That argument doesn't say the discrimination claims.
Right.
But yeah, so I'll explain the discrimination position in a moment, because there is a different argument. But firstly, just to make it very clear that this is a non-point as far as the financial claims are concerned.
Yes.
And I could take you to be very clear what the financial claims are and where they sit, but it doesn't get Mr. Perror anywhere, because it doesn't change the analysis of anything that we've looked at.
Not in relation to the financial claims.
Yeah, and to reiterate, we know what the financial claims are because they're very clearly set out. For example, at page 24, the claim submission to the SCT. So that's dealt with. As far as the discrimination goes, the question remains: when were they brought to court? Same terminology that we've been dealing with already. And we come back to the same analysis, which is that they were only brought to court on one occasion. The brought involves, it's an active verb, it involves claimant doing something to bring his claims to court. And I go back to the same analysis which you've been through in enormous detail already today, that he only brought his claims to court on one occasion, which is when he issued in the SCT.
But that doesn't help if the argument is that he didn't bring his claim to court because court means CFI, and he didn't bring when he brought his claim to the SCT, he didn't bring his claim to the court as defined.
Well, he did, in the sense that there was a single claim which was transferred, and it could only be brought on one occasion. And so we say he has done enough, because for all the reasons we've already argued, which show that the SCT has to be seen as an extension of the CFI. Well, and because there is a single claim that transfers, you have to regard this as one claim which is brought on a single occasion. So in short,
yeah,
when he brought it to the SCT, that's enough to fall within the definition, because that was the occasion when it was brought to court for these purposes. Now, there was then a mechanism to transfer that into the CFI. But okay, what you have to read the definition of court in this rule as including the SCT as an extension of the CFI in circumstances.
I was trying to stop you before. I don't understand this notion of the SCT as an extension of the CFI. The SCT is part of the DIFC courts, but it's not part of or an extension of the CFI, is it?
No, of course it isn't in terms of its legal position and jurisdiction, but for the purposes of our argument, the claim got into the CFI because it was because it was transferred from the SCT. Yes. And in that respect only, for the purposes of viewing when the claim was brought to court, we can only look at the occasion when it was brought to this SCT, because that's the only time when a claim was filed by the claimant. We've then got the provision showing that that claim was transferred. So it's an extension. Perhaps I'm using that term metaphorically.
Yes, I see.
In the sense that it's a conduit through which the claim finds its way into the CFI. And for that reason, it does fall within the wording of Schedule 1. Because that is the manner in which the claim was brought to the court of first instance. And just a further point to underline that, it's impossible to regard the date stamped on the claim form in the CFI as the occasion when the claim was brought to court or the transfer date.
For the moment, I don't see that helps you. To say that it wasn't brought to the court when the registry stamped the claim form in the CFI is not the question. The question is, was it brought to the court when, or more specifically, was it brought to this court as limited to or as meaning the CFI when it was filed in the SCT?
Well, I've made my submission.
I don't think you can say it is because the alternative doesn't work. Anyway, I think it's your argument is really what I would characterize as the conduit argument.
It's a conduit argument.
Yes.
I was simply suggesting there isn't any other occasion when you can say it's been brought to the CFI. There is only that original occasion. That was the point that I was making. But I don't need to address you any further on that.
All right.
I'd move on, if I may, to I think two of the other points, Mr.
Just
Perrin.
before you leave that, I've understood from your earlier submissions that if I was against you on that point, Mr. Linstead, you would then seek the exercise of discretion under Article 61(2)(b).
That's absolutely correct. Yes.
All right.
If it was out of time,
Yes.
because the SCT was not the court, it certainly has found its way to the CFI by the time the claim has been issued in the CFI. And so
Yeah.
I repeat all the same submissions about extending the time.
Although the difficulty with that is that it sort of goes against what you were saying before in that was it brought to the CFI when it was transferred? I don't know. I might have to think about that earlier in the day.
I move on to the point about the point made by Mr. Perrin about the rules of service being different in the SCT and the CFI.
Yes.
We are not trying on the claimant side to rely on the service regime in the SCT. That's not part of our argument. So the fact that the service provisions are different is neither here nor there in terms of what we say the significance of the email written on the SCT acknowledgement of service is. I don't need to say any more on that point.
No.
And as to the defendant saying it reserves its position on the limitation point, clearly it's either got to take the limitation point or it hasn't. It can't do both. And I would underline the points, Your Honour, that you made about issue of estoppel will clearly apply. It is, if it's a matter you're going to determine, then it will determine matter for all purposes.
It's not a matter I have to determine now. simply the two questions that I have to determine are, one, whether first, has or does the defendant and has the defendant made the application now that the limitation, its limitation point, and Mr. Perha has confirmed that yes, the defendant does make that point. The only other point I have to make is that whether the defendant says it reserves its position or not, I am not endorsing that position. I'm not receiving the application on some basis that I authorise or say that estoppels are not going to apply. They either will or won't, and that'll be a matter for parties at a later time.
Absolutely.
All right. Well, thank you.
Look,
yes,
sorry to interrupt. Just one
thorough joinder.
61(2)B, the points made.
Yes.
And to exercise discretion under that, what we say in relation to that point is that we will argue, and in our defence, and we reserve the right to argue that it was not a continuing act as has been characterised by the claimant. So therefore, any finding that the court makes on that, we will not be bound by, because we've simply not had the opportunity to argue otherwise. And that's why we reserve our rights.
Well, again, I think that's an argument for another day if it comes up.
I made the point. Thanks so much. Thank you.
All right. Well,
can I will just respond to that, bearing in mind that this hearing is being recorded.
Yes.
If the point is going to be taken that for reasons based on the facts, the limitation date is not the date that is set out in the defendant's skeleton argument on a subsequent occasion, then that is a difficulty. And you need to make a decision on the argument as it's been put before you now. I would agree that there's nothing further you can say or need to say about the point, but I do take exception with the suggestion that the defendant can alter its position at a subsequent hearing. That's as much as I need to say at the moment.
Thank you. I think you've both foreshadowed or sometimes said put your position on the record.
Yeah, as long as our position's on the record, we're clear on that, and we say it's the long stop date. Thank you. Thanks very much.
All right. All right. Well, I think that does conclude the hearing. I thank you both for your assistance and for your instructors, or those who've assisted you in making these submissions, and I will reserve my decision. So thank you. That concludes today's hearing.